Yes.
It is almost 1:15 in the afternoon. We're back on the record. Mr. McClure and I presiding over this hearing. We have Mr. Weeks on the witness stand, and we have Ms. Hardy cross-examining. Ms. Hardy, are you ready?
Yes, I am. Thank you.
Please proceed.
Good afternoon, Mr. Weeks.
Good afternoon.
You're a vice president of Tumblr Operating, correct?
That's correct.
And Tumblr does not currently operate any wells in New Mexico, does it?
That's correct.
And it does not have any approved APDs in New Mexico, correct?
Yes.
And Tumblr doesn't currently have any facilities registered with OCD that it operates in New Mexico, correct?
Yes.
And Tumblr isn't running any rigs in New Mexico, is it?
No, it is not.
Okay. Your affidavit states that you've worked on New Mexico oil and gas matters since 2015. Is that correct?
That's accurate.
And you're familiar with the factors OCD considers in competing pooling cases, aren't you?
The 7 factors,
Yes.
I probably need to have them in front of me, but yes.
Okay. And share my screen, and hopefully I've got the right thing here. Okay. And this I will represent to you, and I will show you, is Tumblr's pre-hearing statement. Have you seen this document previously?
Without having reviewed the entire thing that you're displaying on the screen, yes.
Okay. And I'm just scrolling down. It lists the 7 factors that are considered by the division in pooling cases, doesn't it?
It does.
Okay. And it states that the factors basically weigh in Tumblr's favor. Is that your understanding of Tumblr's position?
That's accurate.
And I'd like to show you paragraph 25 of your affidavit, which I can pull up. Okay. Okay. And this is, I will show you your affidavit in this case, which has been marked as Exhibit A. Okay. And if we look at paragraph 25, sorry for the scrolling. Actually, it's paragraph 26. You state that title shows that Tumblr controls approximately 9% of the working interest in its proposed units, correct?
Yes.
And Marathon holds approximately 43%, correct?
Yes, that is correct.
Okay. And that's also shown on your plat exhibits, correct? You pull them up if you would like. So it looks like these are your plats marked as Exhibit A2, correct?
Those are the plats marked as Exhibit A2, yes.
And then you have marked as Exhibit A3 the recapitulations of interest for each case, right?
No, Terrence.
Sorry, I thought I heard something.
Yes. I think someone wasn't muted online. So your recapitulations are marked as Exhibit A3, and they show the working interest owners in the proposed units, right?
It shows the working interest owners we are seeking to pool in the proposed units. That is correct.
Right. And it identifies Tumblr's interest up here as 8.94%, right? Roughly?
Yes,
Okay. And then Marathon's interest is shown down here at 43.44% approximately, right?
yes.
Okay. And so to be clear about what this means for purposes of the division, about 90% of the working interests have not signed on to Tumblr's development, correct?
88%, correct.
Okay. And Marathon owns about 34% more interest in this acreage than Tumblr, doesn't it?
That is correct.
Okay. So the working interest control factor does not weigh in Tumblr's favor, does it?
The working interest control factor does not weigh in Tumblr's. Marathon has more working interest than Tumblr does. That is accurate.
Okay. And since Tumblr only owns about 9% of the working interest, it would only pay 9% of the cost for developing this acreage, correct?
That is correct.
And the other working interest owners would pay approximately 90% of the cost, right?
That is also correct.
Okay. And it's your position in this case that Tumblr should be allowed to proceed with its development when it only owns 9% of the interest and is only paying 9% of the cost. Fair?
Absolutely.
Okay. And one question for you on your plats, and I'm asking you this because you mentioned Marathon's plats as, and you were sort of disputing or quibbling that they didn't break up the ownership interests. And my question is this: are these separate leases in the tracts that you're showing?
In the exhibit that you're showing, which is marked as, is this A3?
Yes.
Perfect. Page 125 of 130 of 328. What we are showing is a number of different things. We break up the tracts by working interest ownership within the common working interest ownership within a geographical area. We also identify the separate BLM or state leases that cover each one of those tracts. Tracts 1 and 2 are both covered by the same, tracts 1, 2, and 3 are all covered by the same BLM lease, but the ownership interest in each of those tracts is different.
Understood. So you're showing, or there's a difference between the leases and the ownership interest.
Yes, there is a difference between leases and ownership interest.
And those are different ways of depicting a unit recapitulation, correct?
Yes, that is another way to depict recapitulation.
Okay. Okay, and I wanted to look at paragraph 26 of your affidavit. Okay, and now it's actually 27. And the way I understand that paragraph is that you're stating that Marathon has delayed this development, correct?
I'm stating that in the 8 years that Marathon has owned an interest in this acreage, it has yet to develop a well, despite it having APDs for developing 17 wells and a valid pooling order wherein they were identified as the operator of this development unit.
We talked earlier, though, and you're aware that Marathon was acquired by ConocoPhillips in November 2024, correct?
I am aware that Marathon continues as a wholly owned subsidiary of ConocoPhillips since November of 2024.
And that's not my question. You're not answering my question. My question is, you're aware, aren't you, that Marathon was acquired by ConocoPhillips in November of 2024?
Yes,
Okay. And you don't mention that in your affidavit here in this paragraph, do you?
I don't, because Marathon continues to be Marathon.
If you would just answer my question, this is going to go a lot faster. Isn't it prudent for an operator that acquires another company to thoroughly evaluate development plans of the entity it acquired before proceeding?
Absolutely.
Okay. And here in paragraph 28, you're talking again about the timing of the development. And again, you don't mention the acquisition that occurred in November of 2024, do you?
I don't.
Okay. And you state that no definitive spud date has been provided, correct?
That is accurate.
But the pooling order that's issued in this case will include timing requirements on spudding and completion, right?
That is correct.
Marathon has permits for all 17 of its wells, right?
I'm sorry. Marathon has permits for 17 wells. That is correct.
And those are federal permits that were obtained from the BLM, right?
That is correct.
It typically takes a minimum of 6 months to get a federal APD, doesn't it?
It can take anywhere between 4 months to 6 and beyond. That is correct.
And a BLM permit costs about $12,000 per permit, right?
That is correct.
Tumbler does not have permits for any of its 31 wells, does it?
It does not.
So even if Tumbler obtained a pooling order from the division, it would then need to begin the process of applying for federal APDs. Correct?
That is correct.
And well plats have to be surveyed before an operator can apply for permits, correct?
That is correct.
And Tumbler hasn't obtained surveys for its wells, has it?
We have not obtained surveys for its wells yet. Correct.
Okay. And do you know if Marathon has obtained surveys for its wells?
Are you talking? Oh, I know that Marathon has surveys. The C-102s attached to its exhibits in this pooling case do not match the C-102s attached to its permits that have been filed with the NMOCD. So I'm not sure to which plats are you referring?
Sure. The plats that are filed with the OCD include surveys, right?
The plats that are filed with the OCD in the hearing or for the permits?
For the permits.
They do include surveys. That is correct.
Okay. So Marathon has permits for its wells and surveys completed, but Tumbler does not, right?
That is correct.
Okay. And let's look at your well proposals, which are in your, I believe it's Exhibit A5. Okay. And is this Tumbler's April 25th, 2025 well proposal?
That appears to be correct.
I think it's A4.
That could be. It looks like it's not marked. So I'm not sure.
Yeah, the sample well proposal letter and AFBs are Exhibit A4.
Okay. So referring to A4, that is Tumbler's April 25th, 2025 well proposal, right?
Yes.
Okay. And then let me just apologize for scrolling here. Okay. And then the document I'm showing on the screen is part of that same exhibit. And this is a May 14th, 2025 correction letter to the proposal, right?
That's correct. We clarify a typo.
And it was the difference between the last take point being from the east line versus from the west line, which was a typo in the first proposal, right?
That's correct.
Okay. And then Tumblr sent a second proposal correction on September 8th, 2025, right?
That's correct.
Okay. And in this one, there had been an error on the township and range, right?
There was an error for the bottom hole location in the township and range. That is correct.
Okay. Okay. And looking back at paragraph 29 of your affidavit, you're talking here about negotiations between Tumblr and Marathon, right?
That is that. Yes.
Okay. And you reference a number of communications here, and I think we covered this a little bit earlier in the hearing to some degree, but you're referencing email communications with Marathon representatives, correct?
Yes.
Okay. And I'd like to look at the email here that is referenced in your paragraph 29A. And you're stating here that, and I'm reading the second sentence of that paragraph, for example, after TOP submitted one trade concept, Marathon responded that it didn't, quote, have the time to go through our various portfolio to put a trade schedule together for your consideration. Did I read that correctly?
You did.
Okay. And just to be clear, you weren't a party to these email communications, right?
I was not.
Okay. Just have to get to the right document. Okay. And I've put up here on the screen April 9th email from Sean Miller to Chris Villarreal. And is this the email that you're referencing in your affidavit?
I'm sorry. Could you scroll down a little bit so I can see the prior emails?
Sure. A long email thread. And I guess my question really is, your affidavit's referencing an email from Mr. Miller stating that Marathon, and you've quoted it, basically didn't have time to put together a trade proposal for you, right?
Yes.
Okay, and so is this the email that you're referencing?
Yes, it is.
Okay, and it says, I can understand our non-op positions would be of interest. However, my team and I don't have the time to go through our various portfolio to put a trade schedule together for your consideration. That's the part you quote, right?
I believe so. Yes.
Okay, and then it goes on to state, if Stronghold wants to pitch a trade deal, please send in an offer with the specifics to the interests. In all candor, our non-op budget is considerable. We value our near-term non-op positions with good operators, such as the ones you listed, which is to say a trade would have to be rather attractive to consider, but you never know till you propose. Is that what the email actually, the entire text of the email?
That is the entire text of the email.
Okay, thank you. And I'd like to move the admission of this email as Marathon Cross Exhibit 1.
Okay, any objections?
Not so long as it includes the entire email chain.
Okay, Ms. Hardy?
That's fine.
Okay, so I would like to be able to keep track of this. So you're offering, how are you going to mark this?
Marathon Cross Exhibit 1. if that's acceptable.
Hold on. And how many pages will it be?
It is 5 pages.
Okay. Thank you.
And may I ask whether it includes the entirety of the email chain, including the emails that were exchanged after this email? Because I don't see that that is included here.
No, it's not. And it's the email that Mr. Weeks referenced in his affidavit. He's referencing this specific email.
Okay. So I would just request that we be allowed to
This is,
offer any subsequent emails that relate to this email chain.
I mean, subject to an objection that's sustained? Yes, of course. And this is from Mr. Villarreal, who's going to testify. So you can question him about this and his subsequent emails that you are asking about. And if you want to admit them as evidence based on this new exhibit, then go ahead and ask at that time.
So I can't ask Mr. Weeks to do that. I mean, this is, as the landman expert, he has reviewed all of the communications and offered as an exhibit A5, which has not been objected to. And so it seems to me I should also be able to do that through Mr. Weeks as well.
Well, but we have a better witness here in the house with us. It's the man who actually wrote the email and had this exchange with the other company. Why not do it with him? I mean, if he wasn't here, I would say makes sense, but we have him here.
I guess we will see how their objections to Mr. Villarreal's exhibits pan out before we determine how that plays out.
So this so this exhibit is admitted.
Thank you. And then Mr. Weeks, you reference an email here in paragraph 29B as well. And here you're referring to a March 2024 email, correct?
That is correct.
Okay. And that was prior to Conoco's acquisition of Marathon, right?
I believe that that is a typo. As to March 2024, I believe that should be March 2025.
And you haven't provided that email anywhere, have you?
We have not provided that email as an exhibit yet.
So sitting here with you on the stand, I don't have anything to look at, and neither does the division to determine whether those statements were accurate, right?
Sorry, could you repeat that question?
Sure. If we don't have the email and there's no way to confirm that those statements are correct, right?
I believe we could pull up the email. I believe your client also has the email.
So do we have a copy of this email that you're referring to, Ms. Hardy?
Well, it's dated March 2024, so I don't have any emails from March 2024.
Does someone have them?
So he's saying now that it's March 2025.
It was, yeah, there was a typo in my statement. It should have been March 2025.
So Ms. Shaheen, will you make a note of that typo and correct it when you resubmit the exhibits?
Yes, I will correct the typo and I will also introduce into evidence the email that's in
I think
question.
at this point, it's probably best.
Okay.
So since you wanted to before, let's do it now. Do you have anything?
Oh, to do it right now?
I think so. Do you have it?
I need to find it before I can do that, and I'll
Okay. Do one of your witnesses have it, do you think?
have to look. So I can do that with Mr. Weeks on redirect, or I can do that with Mr. Villarreal.
So Ms. Hardy, let me make sure I understand what's going on while Ms. Shaheen and her client try to find this email from March of 25. You're questioning this witness about an exchange he had, or no, not he had. an exchange that Mr. Villarreal had with whom?
Well, I don't know that from his affidavit, which is part of the problem.
That's the witness now?
Carolyn Frederick, I believe, is, it's Carolyn Frederick and possibly also Sean Miller.
Now, I know that we have Mr. Miller in the room with us. Is it possible for you to get a copy of this email?
Now that I know who it is from and the date, yes, I think so.
Okay, I think so too. It shouldn't be all that hard. And where are you going with this is the next question.
Well, my point was that this email was before Conoco acquired Marathon. So the fact that this communication was made by apparently or allegedly by a representative of Marathon prior to an acquisition that's no longer involved, I don't think it is helpful to Tumblr. I think it hurts Tumblr's position.
I see.
But
When you say no longer involved, I thought the testimony prior was that there was, correct me if I'm wrong, some sort of a merger where Marathon stayed as a separate entity and those individuals are still around. So I'm confused by what you just said.
yes, so there was both, my understanding, and I'm not an expert on these corporate transactions by any means, is that there was a merger and an acquisition, components of both, but that the individuals who would have been involved in this development, who worked with Marathon, particularly on the land side, are not involved and are not continued to be employed by ConocoPhillips. So there's a new ConocoPhillips team that has taken over these assets and this development.
And Mr. McClure, I just am speaking to you directly. This is not evidence what the attorney is telling me, but I'm just trying to get some orientation here, and I appreciate Ms. Hardy helping me here. So do you have a date for this? That basically you're saying that certain people are not in the picture anymore. As of what date?
The date of the transaction was November 2024.
So this March date matters.
Exactly.
Okay, all right, I understand. And Ms. Shaheen, did you acquire this email? So Ms. Hardy, can we wait just a minute or two while Ms. Shaheen obtains this email so she can put it on the screen? We can get it marked. Sounds like it'll be your exhibit again,
Yes.
don't you think?
And I think I have the email as well, but it will take me a minute to find it now that I
Okay.
know what it is.
All right.
I think I have the email
Okay.
and I can share
Great,
and
would
we
you
can
please?
see if someone can confirm that this is the email. Oh, it looks like I got kicked off of the Teams meeting. Okay, I'll have to sign back in.
So I'm not sure what we're looking at. You want to tell me?
This is a March 11th email with Ms. Caroline Frederick, and I think we will need to ask Mr. Weeks if this is the email, the March 2025 email that he's referencing in paragraph 29.
Okay, hold on. Don't ask that yet. So Ms. Hardy, this is now your witness. You're cross-examining. We have something on the screen. Can you lay a foundation with your witness about this?
He's Ms. Shaheen's witness, right?
It's your witness now.
But now, okay.
You're-
Yes, I can do it.
For purposes of, I don't want
Yes.
to pass him
And
back.
I guess I need to see the entirety of well, let me ask this. Mr. Weeks, you have a statement here in paragraph 29B of your affidavit, and this is a quote. Marathon's landman stated, quote, "We don't need Tumblr's help to drill our wells." And then you have it again there, I think is an error. We don't need Tumblr's help to drill our wells. And I don't know where those quotations are coming from. I've never seen an email where Marathon has stated that. So I want to know where you're getting that information from.
There is an email that states that. Whether this is the email or not, I'm not certain. Can we perhaps scroll through the email to see?
I'm not finding that statement in this email.
Then this is not the correct email.
Okay.
But we do have this email up. It was at request of Ms. Hardy to get this email. So do you want to continue about this email and then we can deal with some other email after this?
Yes, if Ms. Shaheen could scroll up. And your affidavit is mentioning a March, and as you said, you think it's an error and that it should be March 2025, and it's an email from Ms. Frederick, right?
I believe that to be
Okay,
correct.
and then this is an email that Ms. Shaheen has put on the screen, March 11th, 2025, from Ms. Frederick to Mr. Villarreal, stating, "Good morning, Chris. Absolutely, the team is very much concerned with maintaining production on the Madera wells. As to the rig situation, let me talk to the asset team and verify whether availability is an issue and if that is something we'd be interested in." Correct?
Yes, that's correct.
Okay. And then Ms. Shaheen, if you can scroll up. And there's an email from Mr. Villarreal to Ms. Frederick. Okay, and then if you can scroll up. Okay, and can you scroll up a little bit more, Machine? Thank you. So this is the email that I have seen, and it's dated March 19th, 2025 from Ms. Frederick to Mr. Villarreal regarding rig availability. And it says, "Good morning, Chris. Rig availability isn't an issue for this project. We intend to drill these wells ourselves and won't be needing external assistance. Really appreciate Tumblr's willingness to collaborate, but we're confident in our current approach and timeline. I'd love to better understand your perspective. Besides the leasehold concern, what's driving the urgency around Goliath for Tumblr? Thanks so much." Did I read that correctly?
You did.
Okay, and is that the email you think you were referencing?
Yes, it is.
Okay, and so it doesn't say we don't need Tumblr's help to drill our wells, does it?
It does not.
Okay, so that's an incorrect quotation.
I misquoted. That's correct.
Okay, thank you.
I'm going to object because I don't know that that's an accurate portrayal of what this email says that Ms. Hardy is stating.
Okay, well, the question was asked and answered and there was no objection. Now there's on redirect, if you want to discuss this with your witness, you're more than welcome to, but at this point, the objection is a little late. It's already been answered. So
We'll come back to it. Thank you.
overruled, but you have an opportunity to clean this up if you need to.
Thank you.
Now, before we continue with this line of questioning, is this the email you wanted?
Yes, it
Okay,
is.
good. Do you want to introduce it into evidence and mark it?
Sure. I would mark it as Marathon Cross Exhibit 2.
Okay, and how are you going to differentiate it from 1? I mean, I know there's 1 and 2. I got that already. So what makes it different?
It's a March 19th, 2025 email from Ms. Frederick to Mr. Villarreal.
So this is a 319 email, and the other email was a what? Take your time.
April 9th,
April 9.
2025.
April 9, so a month later, or 2 weeks later. Okay, I'm with you now.
And again, subject to the rule of completeness that we can have the entire email chain included in the exhibit.
Yeah. Yes, I've already said that multiple times, Ms. Shaheen, so we don't have to keep going over that again. You just make a motion to a request to admit it, and it'll be considered. So, Ms. Hardy, it is admitted into evidence, both of your cross-examination exhibits. Do you have more questions based on this?
Not based on
Oh.
that email.
Then please continue.
Okay, if I could go back to sharing machine. Okay. I wanted to look at your summary of communications. Okay, and this is your exhibit A5, I believe. It's a little difficult for me to read. Actually, I think it's A6. Is this your summary of communications?
For the record, A5.
Is it A5?
It is.
Yes.
Okay, I think I got them wrong because I couldn't read the headings due to the page numbers from OCD.
Yeah, if you look at the index, you'll see that it's A5.
Right. Okay. So this is your communication summary, correct?
Correct.
Okay. And looking at this here, well, it starts in February of 2024, correct?
Correct.
And it goes through many entries here. And this section of this summary is all the communications between Marathon and Tumblr, right?
I don't know that it is absolutely every single communication between Marathon and Tumblr.
I understand. Let me clarify that question. What I was trying to get at is that all of these entries deal with communications between Marathon and Tumblr.
I believe that there may be some actions in there as well.
Okay, let me clarify. You've got other sections of this communications log that apply to other parties,
That's correct.
correct? Okay, so these pages, let me count them. 1, 2, 3. 3 pages of single-spaced entries deal with interactions between Tumblr and Marathon, right?
Yes.
Okay. So there has been a lot of back and forth between Tumblr and Marathon since February of 2024, right?
There has been, yes, quite a bit of communication.
Okay. And I haven't counted up these entries. Have you?
I don't know that I have personally counted them, but I believe it's somewhere close to 70.
Okay, thank you. And is Mr. Villarreal going to cover questions regarding the AFEs? Or are you addressing those as part of the well proposals?
I believe Mr. Baker will be addressing AFEs.
Okay, thank you. Okay. Those are all of my questions. Thank you.
Let's go to Mr. McClure.
Thank you, Mr. Hearing Examiner.
I can't hear you, Mr. McClure.
Can you hear me now? Can you hear me, Mr.
No.
Hearing Examiner?
Could it be that your microphone is maybe in the settings, the microphone is not correct?
It acts like it's working for me.
Nope. Do you want to call in?
No, I think it's your guys' speakers,
Oh.
probably.
There is someone who says that they can hear you. It's just that we can't hear you in the room.
Yeah.
Miss
I think
Miss
the
Chance?
speakers in your room.
Something may have gotten bumped. Can you try now, Dean?
Yeah, can you hear me now?
Yes. Thank you.
Okay, sweet. Yep, thank you, Mr. Hearing Examiner. Mr. Baker, oh, Mr. Weeks, excuse me. Can I draw your attention to your exhibits, page 125 of 328? Let me actually get them open my own self.
Miss Hardy, do you, oh wait, no. Miss Sheen, would you share?
Yeah, this should be your summary of ownership, your unit recapitulation.
I'm sorry, Mr. McClure, could you give me the page number again?
125, please, Miss Shaheen. Should be your unit recapitulation.
Is this the right exhibit?
Yes, ma'am.
Oops.
Mr.
Uh-oh. Sorry.
Mr. Weeks, on here where you reference 3% voluntary joinder, do you see where I'm referring to?
I do.
Which persons is that 3% referring to?
If you refer back to page 120 of 328, you will see a list of owners. We have reached voluntary joinder with Luce Incorporated, the three Hamblin Miners Trusts, I believe those are the parties. Oh, and Puma Mineral Partners, LLC.
Oh, over there in track 3.
Correct.
When you say you reached joinder with them, what are you referring to?
They have signed our joint operating agreement.
Okay. Actually, that page is a fine one for my next question. If we could put that back up, please, Ms. Shaheen. On here, you have referenced the 4 different tracks. Do you see what I'm referring to?
Yes, sir, I do.
Each one of these tracks, would it be accurate to say that they're a set of identical ownership? Or set of areas of identical ownership?
Yes, I think common ownership is the defining factor for each of these tracts.
All of the email chains between Marathon / Conical and Tumblr, are you in possession of all those email chains?
I believe so, yes.
If I were to ask you to provide the division with each and every single one of those email chains, do you understand what I'm asking for?
I believe I do, yes.
If the division were to issue an order forced pulling this unit for Tumblr, when would Tumblr be able to drill the wells?
We anticipate that we would commence drilling operations within 6 months of those orders being issued. And we anticipate that we would complete the commencement of we would commence drilling operations prior to the expiration of 1 year from when those orders were issued. The anticipated first spud being within 6 months. And we anticipate we would complete the drilling and completion of those wells within the timeline of the 2nd year of that order.
How many wells is Tumblr proposing,
We're proposing
between all these units?
We're proposing 31 wells.
So you would presume that Tumblr would have all 31 wells drilled before a year is out after an order would be issued?
I'm sorry. I want to make sure that I'm clear.
Yeah, let
We
me
will-
re-ask my question. Um, if an order were to be issued for Tumbler, would it be able to drill all 31 wells within the first year?
I believe that we would be finishing up or we would be mid-drill on a second batch of wells by the end of the first year. We would have commenced all of the wells. And we would complete them and they would be turned in line within the second year.
Okay, so then you would be proposing to commence drilling on a second batch of wells in the second year.
No, maybe would you like me to walk through sort of like the development timeline? Would that be helpful?
Very briefly, please do so.
Yes, sir. Our intention is to commence drilling within the first 6 months of a batch of wells after having received the approved BLM APDs. Once we have finished drilling the first batch of wells, we will commence development and drilling of the second batch of wells, and we anticipate that each one of that second batch of wells will have drilling commenced on it within the first year of the execution of the order. We would complete the drilling of that second batch of wells within the second year, and all wells would be completed and turned in line by the end of the second year.
So let me re-ask my question, make sure I'm on the same page. You're saying that you would commence drilling on all wells before the first year is up.
Correct.
Is that correct? Okay.
Yes, sir.
And that timeline is considering 6 months for approval of APDs from the BLM. Is that correct?
That is correct.
In your experience submitting APDs to the BLM in the state of New Mexico, have you seen where it's taken longer than 6 months to get approval?
Yes, I have.
I have no more questions for this witness. Thank you, Mr. Weeks. Thank you, Mr. Hearing Examiner.
Ms. Shaheen, redirect.
Thank you. I do have one question for Mr. McClure, if I may.
Not sure that it's proper for you to ask the technical examiner a question. Why don't you ask me first?
Okay, because he asked whether we would be able to produce all of the emails if that was requested by the division. And so my question was going to be, do you want us to produce all those emails?
Let's wait till the end of
Okay.
the hearing. And then he'll have a list of things that he wants that the parties submit as an amended exhibit packet. And if he wants them, I think he'll at that point advise the parties. So,
Okay. Any chance I could have 5 minutes
Yeah,
to prepare
sure.
for redirect? Thank you.
If it'll streamline the redirect, of course. All right, we're off the record for 5 minutes. We'll come back at 10. Thank you. All right, we're back on the record. It is 2:10 PM. Ms. Shaheen, redirect.
Thank you, Mr. Examiner. First, we'd like to start by looking at the emails that Ms. Hardy asked Mr. Weeks about. So I will share what I believe is cross exhibit 1, and please correct me if I've got that wrong. Mr. Weeks, can you confirm that this is the email chain that was identified as Marathon's cross exhibit 1?
I believe that to be correct.
And this is the first email in that email chain. Is that correct? The March 28th,
I believe so.
2025?
Yes, ma'am.
And this email is from Mr. Villarreal to Mr. Miller. Is that correct?
Yes, that is correct.
And this is, he's offering to discuss further the future of the Goliath wells. Is that right?
Yes, that's accurate.
And then this next email dated March 31st, 2025 is Mr. Miller's response to Mr. Villarreal.
That's correct.
And can you sum up what Mr. Miller's response was?
Mr. Miller's response was that Conoco was it was taking Conoco a while, Marathon a while to get its drill schedule in order when it merged its drill schedule and drill schedule projects together with legacy projects that were already on their drill schedule.
In here, down in the second paragraph, Mr. Miller asked Mr. Villarreal to send his development proposals or his proposals for some sort of resolution. Is that right?
Yes, that is correct.
And then Mr. Villarreal replies with a proposed starting point for discussions on resolving the issues. Is that correct? Would that be fair to say?
I would say that this is another attempt to start discussions with Marathon in this regard. And in this email, Christopher suggests that potentially a trade could be a solution so that that Marathon's working interest could be increased.
And then Mr. Miller asked whether there are any tracks in mind. Is that correct?
That's correct.
And Mr. Villarreal responds.
Correct. Mr. Villarreal responds and not only identifies 3 different tracts that Tumblr would be interested in trading into for its position. It also identified some other areas or metrics by which Marathon could evaluate its ownership in order to execute a trade.
And he asked Mr. Miller if he has any other options that he would like considered, correct?
That is correct.
And subsequently, it appears that Mr. Miller didn't provide a response. Is that correct?
That's correct. Up until Tuesday, April 8th, no response. Chris had to email Sean again to prompt the discussion.
And then can you summarize Mr. Miller's response here in his email of April 9th?
I would summarize it as, I can summarize it. They don't appear to have the time to expend the effort to review their interests in the tracts that Tumblr had proposed as potential trade opportunities, and instead asks that we propose additional specifics of Marathon's interests in those areas.
Do you know whether there were, here's the final email in this particular email chain. What was Mr. Villarreal's response to Mr. Miller?
Mr. Villarreal's response to Mr. Miller was that it doesn't appear we're not, well, since the pooling orders are going to expire and we want to see this acreage developed, we are sending proposals for Tumblr to develop this acreage.
Turning now to what I believe is cross exhibit 2. Is this the email chain that you discussed with Ms. Hardy that was identified as cross exhibit 2?
I believe so. Could you scroll down a little bit?
Actually,
no, I don't believe this is
not
it.
it. Okay. Let's try this one. Here it is. Does this look familiar? Is this the one that you were talking about with Ms. Hardy?
Correct. This appears to be cross exhibit 2, or the email chain that is the subject of the cross exhibit 2.
And this is the one where you were discussing whether your quote accurately, whether you had accurately quoted this particular email. Do you recall that testimony?
I do recall that testimony.
And can you read this into the record, please?
Certainly. I believe this is from Carolyn Frederick to Chris Villarreal. And it says, "Good morning, Chris. Rig availability isn't an issue for this project. We intend to drill these wells ourselves, and we won't be needing external assistance. Really appreciate Tumblr's willingness to collaborate, but we're confident in our approach and timeline. I'd love to better understand your perspective besides the leasehold concern. What's driving the urgency around Goliath for Tumblr? Thanks so much."
And so would it be fair to say, if you were to summarize this, that Marathon is telling Tumblr, we don't want your help? Is that correct?
I object. I think the email speaks for itself.
And at that point, Mr. Villarreal responded by offering to meet together, to meet with Marathon in Midland. Is that right?
That is correct.
And there was no response to that email. Is that right?
Object. I don't think that evidence is in the record.
Well, let's,
Okay.
Could you ask the question again?
yes. So here is the email from Mr. Villarreal to Ms. Fredericks. And he asked her about a time to meet in Midland. And the next email in this chain is again, Mr. Villarreal following up with Ms. Frederick. Is that correct?
That's correct.
Ms. Shaheen, could you scroll up so we can see the date?
Yes. And that was on March 25th of 2025.
So is that, just can you scroll down for 1 minute? I just want to see the,
Okay.
thank you.
What's the question?
The question was, did the following email Mr. Villarreal had to follow up again because he received no response from Ms. Frederick. Is that correct?
Correct.
Uh-huh.
I think that these questions are better asked to this witness because he would know everything that went back and forth. To ask this witness what he knows about those communications, I think is not the most reliable source. So can we move on from this subject now?
Sure. I mean, I'm only asking him because Ms. Hardy asked him about them.
And you've done that,
So.
and we've covered this close. So we move on now?
Yes.
Thank you.
Ms. Hardy asked you some questions about the acquisition of Marathon by Conoco. Do you recall that testimony?
I do.
And she appeared to suggest that this acquisition by Conoco is why Marathon has not followed through on its proposals. Do you agree?
I agree.
And in your experience, when should a prudent operator review development plans for a company that it is acquiring?
I'm going to object as well, being outside the scope of his testimony as a land man.
We know that it's within the scope of cross-examination question. Did ask him this question earlier. So I'm going to allow the question. So would you answer?
Yes. Could I get it posed a second time, please?
Yes. In your experience, when should a prudent operator, in this case Conoco, review the development plans that have been proposed by the entity it's acquiring, in this case Marathon?
In this case, it's a somewhat more nuanced discussion on that topic. Marathon merged into Conoco and personnel continued on. The land personnel for Marathon were continued to be employees even after the merger occurred. And those employees were, after the fact, either let go, terminated, or left of their own accord. And so I would say that Marathon has continued in existence through that period of time. Additionally, I believe that a prudent operator, prior to making an offer on a $22.5 billion company, would have done some due diligence about how it's going to integrate those assets and those systems into its portfolio for a seamless transition, is what I would say. And so as far as time goes, I would estimate a minimum of 9 months of due diligence would have been done.
Mr. Examiner, I move to strike all of that testimony. I think Mr. Weeks, he is absolutely not an expert on corporate mergers and acquisitions. He has no knowledge of the employees who stayed or left Marathon when it was acquired. This is way outside the scope of his testimony as a petroleum land man for Tumblr.
Yes, I believe Ms. Hardy opened the door to this testimony. She asked about the acquisition of Marathon by Conoco. And I'm just asking, when you have an acquisition, she assumed that Mr. Weeks could testify about the acquisition, and now I'm asking a follow-up question about that acquisition.
No. Well, yeah.
Now, you have the right to cross-examine this witness based on what you just said.
Okay.
But I agree that you did open the door to this testimony. Whether it went further than I hoped it would go is a different situation. You can show how this information is, I'm not saying it is, less than reliable on your cross-examination, and then we'll give it the weight that we deem that it's worth. I'm sorry. Thank you, Graham. Did you catch that or not? You caught it? Good. I don't have to go over that again. So the objection is denied, but you'll have your opportunity on cross, and I understand where you're coming from. But the question was asked and answered, and it stands for what it stands for. Is there a follow-up, Ms. Shaheen, or are you done with your redirect?
The only other thing I was hoping to do is to clarify the typo in paragraph 29A of
Please.
Mr. Weeks' testimony. And excuse me, 29B, where it refers to a March 2024 email.
Hmm.
And I believe that the reference is actually to March 2025 email with Ms. Fredericks, which has been identified as Marathon Cross Exhibit 2, if I'm correct. Everyone
Yes,
agrees.
Nodding.
Sorry, I was waiting for a question.
I thought that was the question.
That is correct.
Thank you. I have no further questions at
Thank
this
you.
time.
Recross.
Yes, thank you. Mr. Weeks, you have not worked for Marathon at any time, have you?
I have not.
And you have not worked for ConocoPhillips at any time, have you?
No, I have not.
You're not a consultant for ConocoPhillips, are
I'm
you?
not.
And you weren't a consultant for Marathon, correct?
That is correct.
And you weren't involved in any due diligence for the acquisition by ConocoPhillips of Marathon, were you?
No, I wasn't.
And you don't have personal knowledge of employees who left or stayed at Marathon after it was acquired, do you?
No, that's not accurate.
Do you have specific information on the number of employees who were retained, in what areas they worked, and who they were?
Do I have specific information on the number of employees that were retained, who they were, and say that last part again?
Well, it's a compound question.
Well,
So
yeah, sure. I will break it up. Well, you certainly don't have any information in your testimony on employees who were or weren't retained following the acquisition, do you?
I do not have anything in my testimony about which employees were retained and which were not.
And you weren't involved in the discussions with the land team at all, were you, at ConocoPhillips or Marathon?
Objection vague.
Well, all of the communications we've been talking about here were actually between Mr. Villarreal and Marathon, right?
No, that's not
Hold on,
accurate.
there's an objection. Whenever there's an objection, you
Sorry.
have to wait
Thank you.
for a ruling so that we can deal with it evidentially. So the objection was vague.
Yes, and Ms. Hardy may have cleared it up after I objected when she said at Marathon.
Right. I think she did. So, I sustain the objection, but she rephrased. So please rephrase what you have. So please answer the rephrased question.
It's not accurate. I have had communications with the employees of Marathon.
Okay. And had you communicated with employees at Marathon regarding this development before the acquisition?
I have not.
Okay. And so you don't know if they are the same people or not, do you?
Sorry, could you say that one more time?
You don't know whether the same land team is working on this matter now as prior to the acquisition, right?
I know that I know that members of the land team that had previously been working on this project from Marathon no longer work on this project for Marathon.
Thank you.
And that, sorry.
And you haven't reviewed any of ConocoPhillips documents or plans regarding the integration of Marathon's assets, right?
I have not.
Okay. Those are all of my questions. Thank you.
Okay, Mr. McClure, did the redirect or the recross bring up any further questions for you?
No, it did not, Mr. Hearing Examiner.
All right. Ms. Shaheen, may this witness be excused?
Yes.
Thank you, Mr. Weeks.
Thank you.
You're welcome. Who's the second witness?
Our geologist, Mr. Dylan Collins.
Mr. Collins. I remind you, you're under oath.
Understood.
Ms. Shaheen,
Thank you.
I will remind you that B6, 7, and 8 are not admitted through stipulation. Go right ahead.
Was there another set of exhibits that were supposed to be here? The rebuttals?
Do you have the tumblers exhibits up there?
I do.
Okay, and you're looking for the marathon exhibits?
I have those.
You have those?
But there was another set of exhibits that.
Oh, the rebuttal
The rebuttal
exhibits.
exhibits. I think maybe Mr. Weeks took them.
They look like this.
Yeah, they're not.
Thank you. Yes, of course. You want to just show them to Ms. Hardy before you give them? Okay, Ms. Shaheen, go right ahead.
Mr. Collins. Do you see here your revised self-affirmed statement?
I see it. Sorry.
I believe it's page 179.
Yes.
And do you affirm that this is your true and accurate testimony today?
Yes, I do.
Do you have any corrections to this testimony today?
The only thing that I like to correct is I said the affirmation sentence twice at the end of my statement.
Okay, so you would get penalized twice for perjury if you're
Yes.
perjuring yourself today. Okay. And if I understand correctly, this exhibit has been stipulated to.
What exhibit number is it? I don't know what you're
Exhibit
looking
B.
at. It has been, yes.
And the attachments there to B1, B2, B3, and B4. Is that correct?
Yes.
So I don't need to
No,
move them into.
They're in evidence already.
Okay.
Wait, can I ask I'm confused because the B1 that I have that was filed does not include, it looked like that, was that an AFE?
What's on the screen?
B1, that's the regional locator map. Let me pull that up and see.
That's what I have as B1.
Yes.
Yes.
Okay.
Is there an objection?
No, but I
Okay.
thought Ms. Shaheen was showing an AFE,
Okay.
and I don't see that as part of this witness's exhibits, so I was confused.
One thing I do want to note for the record, and that is in this revised statement. Mr. Collins, do you recall what was changed in your revised statement?
Yes, I do. There was a typo between the columns of TBD and MD on the well lists. So they are corrected in this one.
And that would be in paragraph
12.
Paragraph 12. So you're saying that the exhibits that that were submitted on Wednesday. This was actually submitted again as an amended exhibit on Friday, and the TBD was
They were swapped.
swapped with the MD.
Yes.
Okay, I wanted to make that clear for the record
Thank you.
because I told Ms. Hardy something different.
Okay, thank you. So in other words, TBD would be in the second column and MVD would be in the first column.
That's what the original submission, yes, TBD was on the right and MD was on the left, and that was incorrect.
So in other words, the data hasn't changed, just the column heading changed.
Just the column heading.
Okay, thank you.
Let's briefly walk through your exhibit, and you can summarize the highlights here.
Sure. So the first exhibit, there's the locator map to give everybody orientation as to where we are, to measure the basinal features in the Northern Delaware Basin. B2 is a series of structure maps. They are all the way from the Avalon down through the Wolfcamp B, along with offset wells and a well log that's on section for reference. On the well logs, there are dots in the depth tract that represent Tumblr's chosen landing points. There's also on each of these maps, there's a cross-section annotation that leads to exhibit B3. So the annotations on the previous maps, structure maps, and the annotations on exhibit B3 are the same annotations. They represent the same wells that are selected for this cross-section, and this is a cross-section that is typical for this area. And what we can see here is that we are in the deepest portion of the Northern Delaware Basin structurally. There's a slight bowl feature in the structure of nearly all the formations.
And going back to so we have your subsurface maps through the Wolfcamp A, the Wolfcamp B.
Yes.
And then your cross section here.
Yes.
And Tumblr proposes to drill south to north. Is that correct?
Yes.
Is there a preferred orientation here?
So yes, it's pretty evident that operators have chosen this north-south direction because the evidence suggests that regional horizontal stresses are maximum in an east-west direction, and you have to align your well bores perpendicular to that maximum horizontal stress direction to invite fractures to grow away from the well bore. So if you were to drill the other direction, if you were to drill east-west, the fractures would still grow in an east-west direction because of regional stresses, and that would be parallel with the well bore, and you would not reach very much reservoir at all.
From a geology perspective, how does Tumblr's development differ from Marathon's?
So we choose to develop all good rock nearly simultaneously. As you've heard in other testimony, we choose two different batches, and I'll let our operations engineer say why, but we choose to do two different batches. But geologically, the first batch, we would co-develop the third bone sand, the Wolfcamp A, and the Wolfcamp B all together. The reason we would do this is because there are no meaningful fracture stimulation barriers in the rock. So if you were to go ahead and place wells in the Wolfcamp A and the Wolfcamp B, and you were to fracture stimulate these wells, there is no rock impediment to keep them apart. So you're only going to keep them apart either through distance or through completing them together and distance.
And have you reviewed the rebuttal exhibits that have been offered by Marathon? I believe, let's see which ones they are, that relate to geology.
Yes,
Um,
I've reviewed those exhibits.
Before you continue, they're not in evidence.
That's right.
Just reminding you, they're not in evidence.
And it gets a little convoluted because we do have some, I mean, we have objected to those exhibits
Right.
because we believe they should have been part of the direct case.
Right.
At the same time, we do have rebuttal to that. If it is considered rebuttal, we do have rebuttal
Right.
to that. And so if you would like, we can address that now. It may be better for us to address it after Mr. Patrick, I believe. Is it?
Well, they're not in evidence let's just stick
Right.
to the crux here. They're not in evidence. So by sitting here and talking about them, I don't think it's proper. You've objected to them. That's fine. But I think we'd have to wait until Ms. Hardy makes her case and shows us that they are proper rebuttal before we would consider admitting them over your objection. But you can't have your cake and eat it too.
Right. And I don't really want that. I just want to make sure that we don't miss our opportunity to respond to their proposed geology rebuttal exhibits.
Sure. It just seemed like you were addressing it, which is why I stopped you.
Okay.
Okay, so.
I think
why
we're
don't
on
you-
the same
Why
page.
don't you continue without talking about those rebuttal exhibits for now?
By the
Can
way,
you
can I,
summarize?
by the way, can I go back to finishing the differences between the development? I'm sorry, I didn't complete that.
Oh, I'm sorry, I cut you off. My bad.
Maybe I slowed down.
Um,
So the other differences are, we choose what I think to be a more proper spacing for the Sharely intervals, which would be the Wolfcamp A and the Wolfcamp B, which is spacing at 880 feet between wells in the same interval. And that equates to 6 wells per section in the Wolfcamp A. And then when you stagger in the Wolfcamp B, that makes 5. And then further, we believe the correct spacing for the sandy intervals is 4 wells per section. That would be the second bone sand and the first bone sand, both of which are different from the Marathon proposals. They chose 3 and 6, 3 in the second bone sand, 6 in the first bone sand. And then obviously we propose wells in the Avalon, which is also, in our view, very high quality rock. Sorry.
Back to your statement, in paragraph 11, and let me pull that back up here. This is page 181.
I see it.
Paragraph 11. You summarize your opinions based on your review of Marathon's geology exhibits. Can you
Yeah.
explain to the hearing examiner?
Yeah. So some of this I just said previously. We think that 4 wells per section of Wolfcamp A is inadequate to develop that resource. We think that if you do not co-develop the third bone sand with the Wolfcamp A, you're going to harm the future potential wells in the third bone sand. So we think they need to be developed together through a parent-child effect. I think that 3 wells in the second bone sand is not enough to efficiently develop that resource. And in the opposite direction, I think that 6 wells in the first bone spring sand is too dense because it's a more sandy interval with higher permeabilities.
And in short, in your opinion, will Tumblr's proposed development best protect correlative rights and prevent waste?
Absolutely.
I pass the witness.
Thank you. Ms. Hardy?
Thank you. I just have a few questions.
Before you do, I'm sorry, I have to clarify something. So now you know that B6, 7, and 8 are not admitted. You know that. Were those in some way rebutting evidence that's not in evidence now? I see. Are those the rebuttal to the rebuttals? They are. Okay. So then they're not admitted, rebuttals not admitted. I just wanted to clear that up, Ms. Hardy.
Thank you. Good afternoon.
Good afternoon.
me just pull up your testimony. I just have a couple of questions for you. Mr. Collins, I've put up on the screen here your resume that's attached to your testimony.
I see it.
Okay. And you show that you are currently the CEO of Yukon Exploration Operating, correct?
Yes.
Okay. And Yukon Exploration focuses on the Midland Basin in Texas, right?
Yes.
Okay. And your resume also states that you're the Petro Technical Director for Stronghold Investment Management, right?
Yes.
Okay. And Stronghold is an investment company, correct?
Yes.
Okay.
And an investment manager. Yes.
Okay. And with respect to geology, wouldn't you agree that it can vary significantly over 15 miles, particularly in this area?
Sure. It depends on anisotropy and correlation lengths, of course.
Yeah.
In this area, it depends on which interval you're talking about.
And with respect to Tumblr's proposed Avalon wells, your testimony and exhibits don't include any discussion of H2S, do they?
No.
Have you evaluated whether the Avalon produces high levels of H2S in this area?
I have evaluated it.
Okay. But you didn't include that in your discussion, correct?
No, I did not.
Okay. And the Third Bone Spring has a very high water cut in this area, doesn't it?
Can you define very high?
More than 70%.
I think we have a different definition of very high, but sure.
And I think, if I'm recalling correctly, your testimony or Tumblr's exhibits say it's at least 70%.
Yeah,
Right?
70%. Sure.
70%. Okay. Okay. And when there is a high water cut, that reduces obviously the amount of oil that's produced by the wells, right?
That's not true.
Well, let me ask it. Let me rephrase it. You have to produce a lot of water to get the oil when there is more water, right?
That's pretty self-evident. Yes.
Okay. Thank you. Those are all my questions. Thank you.
Thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Collins, if I can direct your attention to your gun barrel diagram. It's on page 199 of 328.
Yes, I'm getting there. I'm here.
When you reference the two different batches, is those batches separated by formation? Or horizon might be the better way to say it?
Yes. I would recommend that the batches are drilled, the Wolfcamp A, B, and Third Bone Sand together, and then the subsequent batch to be further uphole or shallower.
And you might have testified earlier, and I may have missed it. Did you reference that there is no frac barrier between the Third Bone Spring carbonate and the Second Bone Spring?
No, I did not say that. I was referencing the Wolfcamp A and the Third Bone Spring sand. If maybe I misspoke. And
No, that's what you said.
Yeah, it sounds right. I was just confirming. I wasn't quite sure.
Sure.
I did hear the Third Bone Spring and Wolfcamp A. So to confirm, you believe there is a frac barrier between the Second Bone Spring and the Third Bone Spring carbonate?
I think that the competency of the frac barrier, between the Third Bone Sand and the Second Bone Sand, absolutely. That is a very competent frac barrier in the logs you can see in the gamma ray, the lithology log indicate. Yes.
Okay, so comparing Marathon's proposed units to Tumblr's proposed units, which horizons could not be drilled after Marathon's units were drilled out?
Third bone sand, third bone carb. Or sorry,
Now,
it
why
can
do
be, sorry, they can be. I think that the potential for the well's productivity would be damaged based on a parent-child effect.
And is that accurate for the third Bone Spring sand?
Yes, I think especially for the third Bone Spring sand because of the Wolfcamp A.
But you believe it to also be the case for the third Bone Spring carbonate?
And the second Bone Spring sand. So if you were to come in, if you were to say you can do the third bone carb after the Wolfcamp development, I would say yes. But if they were to do this full 17 well development, I think that there will be parent-child effects in the third bone sand from the Wolfcamp A and in the third bone carb from the second bone sand.
And is that despite there being a good frac barrier between the third Bone Spring carbonate and second Bone Spring?
So the target for, hopefully I'm answering your question here. The target for the third bone carb is in the Harkey Mill sand, roughly around 11,570. There's only a couple 100 feet between that and the second bone sand. Now, I cannot say for certainty that there would be absolutely a strong parent-child effect, but there's strong evidence everywhere in the Permian Basin that that's a high risk factor with that kind of closeness.
If I can draw your attention to one page up, that's your cross section on page 198 of 328.
I'm here.
If I were to ask you to amend this exhibit to include the API number for each of those wells on that cross section, do you understand what I'm asking for?
Yes, I do.
Okay, thank you. No more questions.
Thank you.
Thank you, Mr. Collins. Thank you, Mr. Hearing Examiner.
Thank you.
Ms. Shaheen, any redirect for this?
No, thank you.
Thank you, sir. Your third witness?
Mr. Walt Baker?
I remind you, you're under oath.
Yes, sir.
Thank you.
May I sit?
Please.
Thank you.
And Ms. Shaheen, I remind you that C5 is not admitted. I don't know what it is. It's your exhibit. Yes. It is. Did you want it? I mean, it's part of your packet that you handed me, C5. In your microphone. It says rebuttal to MRO Exhibit A. A number 41. I don't know what the 41 stands for, but that's what it says here on your packet.
I suggest that we go through Mr. Baker's
Sure.
statement and the exhibits that have been admitted.
Sure.
And then perhaps Ms. Hardy can elaborate on why she's objecting
Okay,
to,
fine.
if that works for you.
Sure.
Okay.
And if this rebuttal exhibit is not based on like Mr. Collins' exhibits were based on inadmissible evidence for now, if it's not based on that, then maybe you can get it in.
Okay.
Okay,
Sounds good.
so go ahead.
Turning now to Mr. Baker's self-affirmed statement, page 202 of 328. Mr. Baker, do you accept your written self-affirmed statement here as your true and accurate statement of the facts that you testify to in this hearing today?
Yes, ma'am.
And do you have any changes to that statement at this time?
No, ma'am.
You've prepared the facilities engineering exhibits for Tumblr, is that right?
That's correct.
Let's take a look at first exhibit C1,
Yes, ma'am.
and that is not stamped. 210. Can you summarize for the hearing examiners, Exhibit 210, excuse me, Exhibit C1?
Yes, ma'am. So this is just a general pad location and layout and its proximity to the local produced water, oil, and gas lines for marketing purposes. So essentially what we're trying to communicate is that we're going to be using 4 pads to drill our 31 wells off of and produce or enjoy our production from 2 battery pads that'll be centrally located between the 2 drilling pads. And we've got plenty of pipeline in the area to get our product to market.
How does this compare to Marathon's proposed surface facilities?
Marathon proposed a single central tank battery and 2 well pads, which is essentially 45% reduction in surface disturbance, or 47% versus our proposals. But I should just comment that also is taken into effect that they're drilling 17 wells and we plan to drill 31 wells. And so our plans of having 2 facility or tank battery pads at that well number, we believe as a prudent operator that it gives us redundancy as far as our total production and our total volumes. In the event that there is an interruption at each battery for maintenance or otherwise, total production or 100% of our production won't be shut in. And as far as the 4 well pads with our 31 wells, it gives us a little bit more protection on anti-collision as far as our proximity between the well bores.
And have you done the calculation to have the pad to well to battery ratio?
So what I did was I just took a percentage. So, essentially our disturbance, if we're taking, what Marathon has produced in their exhibits, like I mentioned, it's about a 47% reduction in surface disturbance just between the battery pads and the well pads. However, we'll be drilling 45% more wells, and as far as production forecasts, it's a similar delta, similar difference. So
What is your opinion on Marathon's proposal to use existing facilities?
I don't have much of an opinion on their existing facilities, given that I don't really have that much information as far as what they've provided and what they're using for existing facilities. What I can comment on is that them drilling only 17 wells and using a central tank battery makes sense to me.
Is it fair to say that you can't really evaluate Marathon's assertion that it's going to use existing facilities because they haven't provided the information that's necessary to evaluate that proposal?
Yes, ma'am.
Turning now to the next exhibit, which is C2. Can you describe Exhibit C2?
Yes, ma'am.
Hearing examiners.
So this is just a map. It's demonstrating that we have the ability. So we have a commitment that we'd like to use a majority of recycled water, produced water for our frac operations on all 31 wells. And it just wanted to demonstrate that the area is ripe for the ability to do that. We've got at least 5 recycling facilities in the near 5-mile buffer and plenty of SWDs and a Solaris trunk line that's very nearby to our pad. So it gives us the ability to produce or recycle on the fly if we need to, near pad, as well as do off-site recycling in the farther distance.
Turning now to Exhibit C3. Can you describe this exhibit and the following exhibit, which are similar to the hearing examiners?
Yes, ma'am. So this is the Bone spring spacing unit. There's 4 for each, one for each slot. And it just speaks to, how we are planning to commingle or apply for commingling with the BLM. And so the plan is our facilities will be equipped with well test and meters, or well test separators and meters for each well. And we plan to commingle all the Bone Spring wells together, as well as the Wolf Camp, which you'll see. I apologize. You'll see in the next exhibit.
And this is a similar exhibit, but with respect to the wolf camp, is that right?
Yes, ma'am.
C4?
Yes, ma'am.
And you've reviewed Marathon's exhibits with respect to its proposed facilities, right?
Yes, ma'am.
But again, they didn't provide any engineering support for their proposed facilities, did they?
No, ma'am. As far as I know, it's surface disturbance and location and layout.
Were you able to determine how Tumblr's wellbore design compares to Marathon's?
If comparing to the original APDs, yes, and it's similar. I think the only difference between ours and Marathon's, if those APDs are still going to be used by Marathon to this day, will be that we plan on just drilling a consistent size hole in our intermediate section via 9 7/8, whereas it looks like on the APDs for Marathon, they slim down to an 8 3/4 at some point in that intermediate section. But as far as casing setting points and the hole sizes from there, relatively similar. One note to add, H2S was previously mentioned. We plan to use sour service tested production casing, specifically P110 MS2 rated. So what that means is it's essentially that those tubulars are tested to the NACE chart in region 2, which has been what's been recommended for this area by our partners in the midstream area, where they're obviously seeing a lot of the gas come back and doing the majority of the testing in the area, as well as offset operators that we've talked to as well. So we'll have that across the board in all targets, just to hedge our risks as far as any issues in casing integrity.
And have you considered the H2S handling plans?
Yes, ma'am.
Can you describe that to us?
Yes, ma'am. So as far as operations go, we'll have an H2S plan for drilling, frac, and production. On the production side, there are several different available treatments as far as H2S scavengers go. So if in the event that we see and produce H2S, we'll set up a on-site scavenger system to allow us to get our gas to market without being severely punished.
Have you forecast a comparison of volumes that would be produced by Tumbler and by Marathon in their respective developments?
Yes, ma'am. I've just run sensitivities off of, what our type curves and forecasts are, and looked at a few different timings. And so, depending on how quickly we're able to get the wells online, Mr. Weeks spoke to about a 6-month period and the 2 different phases. Initial monthly average production is roughly 30 to 40% higher than what we would expect if we were going to drill Marathon's development.
In paragraphs 26 to 28 of Marathon's Exhibit A, Marathon suggests that they will be more protective of the surface. Do you agree?
I do not.
Why is that?
Well, maybe I should back up. I think If the total mission is to protect the surface, then I would agree that Marathon is protecting the surface. But if the total mission in totality is to produce the most oil versus surface disturbance, I would say that Tumblr's approach is the best.
So is it fair to say that Tumblr would produce more oil with a comparable surface footprint?
Yes, ma'am.
Well, I was going to object to that question.
Well,
It answered before I could. I think that he doesn't cover production estimates in his testimony. That's addressed by Mr. Villarreal. And I know he's been testifying about it. I didn't get my objection into the prior question, but that's not within the scope of his testimony on direct.
Machine?
Well, similar to my objection that was late, I believe Ms. Hardy's objection was late and that testimony is already in the record.
Well, then I object to this question.
Has he answered this question yet?
Not yet.
Not yet. Okay.
Which question are we objecting to?
Miss-
With
Producing more oil with
a comparable surface footprint?
with less, or I don't recall the question, but it involved increased production based on the service facilities.
I did speak earlier as far as the well count, sorry.
This is it's a legal matter. It's not an evidentiary matter at the moment. Do you, Mr. Court Reporter, do you want to repeat the question that was asked that was objected to?
Yes, give me just one moment. The question was, so is it fair to say that Tumblr would produce more oil with a comparable surface footprint?
And that was what you objected to, and there's been no answer to it, right? No,
No.
the answer is no. Okay. So, Ms. Shaheen, that was the question that you asked. And the objection is that it's outside the scope of this witness's expert area of expertise. Is that correct?
That's correct. And I also think it's incorrect that the surface facilities are comparable because he's testified that Tumblr's operations would involve significantly more surface facilities. So I think
I
the question
object
is
that Ms. Hardy is testifying into the record. I don't believe I think she's misstating Mr. Baker's testimony.
Okay. Well, what she says is not evidence. We all know that, so you don't have to worry about that. But the basis of the objection is that it's outside his scope. So what's your rebuttal or what's your response to that?
And I apologize because my client was talking to me when the court reporter read back the question. So could I ask you to read back the question again?
Sure thing. The question was, so is it fair to say that Tumblr would produce more oil with a comparable surface?
That was,
And if I
that was your
understand,
question.
yes, and the objection is that it's outside the scope of his testimony to talk
No,
about
outside the scope of his expertise.
expertise.
Am I getting that right?
I think it's both. I think it's outside his expertise and his written testimony.
Scope of his written testimony? Okay. So there's two bases for the objection.
And it's outside, and I just want to make sure I understand what is outside the scope. Are you saying that producing more oil, him opining on producing more oil is outside the scope?
Yes, he doesn't address that in his direct, and he's not a reservoir engineer.
Isn't it true, Mr. Baker?
Whoa, what are you doing now?
Oh, I'm asking
confused.
I'm asking the question a different way. Can I do that?
Sure, I can sustain the objection. I was just waiting for a legal response from you so I could make it a thing. But if you want to rephrase, I'll sustain the objection. So rephrase, please.
Okay, thank you. Isn't it true, Mr. Baker, that in determining what is necessary for the batteries, the batteries, you have to confer with reservoir engineering about the estimated production of oil?
Absolutely. Yes, ma'am.
Okay, so in determining, so you're aware of what has been forecast with respect to oil production with Tumblr's proposed development. Is that correct?
Yes, ma'am. I didn't generate the forecast, just using them as.
But you used that to determine that there were 2 tank batteries that were necessary.
Yes, ma'am.
And you use that to consider what other surface facilities are required.
That's correct.
And is it your understanding, based on that, based on conferring with reservoir engineering, that the facilities that you have planned will will result in a comparable surface footprint for the amount of oil that will be produced by Tumblr's development?
Yes, ma'am.
Now, you've also taken a look at the AFEs, is that right?
That's correct.
You've looked at Marathon's AFEs and tried to compare them to Tumblr's AFEs, is that right?
That's correct.
What opinions did you reach in light of your comparison?
And I'm going to object to this line of questions as well. I don't see any information at all, unless I'm missing it. I don't see anything in his direct testimony about AFEs.
Okay. Ms. Shaheen, outside the scope.
Outside the scope of his direct
Yes.
testimony? This brings us to the rebuttal exhibit.
Okay, well, they're not in evidence yet, so do you want to try to admit them?
I just need to make sure I'm looking at the right exhibit. Maybe what I'd like to do first is turn to,
I still have to deal with the objection. So
all
do you
right,
have a response to the objection, or should I just sustain it? You're going to move on.
what I'd like to do is turn to can I get 5 minutes? So I can make sure I know
It's
where.
getting kind of late in the day for the 5 minutes. It's
Is it?
3:12 now. So I'd rather deal with the objection. And if there's a real good reason to have a break, then we will. But can we deal with the objection now? You were asking a question that Ms. Hardy objected to as outside the scope of the direct testimony. I think you're trying to say, well, it's in the scope of his rebuttal. Is that not right?
That's part of it. I mean, I think in considering the facilities, Mr. Baker looked at the AFEs and tried to compare the cost of the facilities.
Well, do you have another witness that looked at the AFEs? Would that Mr. Villarreal have looked at the AFEs?
The AFEs were attached to the well proposal that was attached to Mr. Weeks' testimony, but only the engineers really can testify as to the cost. There was no need for Mr. Baker to testify to our costs of AFEs without comparing them to Marathon's AFEs, which were, of course, attached to their exhibits,
Right.
which is why it's effectively rebuttal.
Right.
And I believe it is within the scope of his expertise as a facilities and operations engineer.
That wasn't the objection. It wasn't that it was outside the scope of his expertise. It was outside the scope of the direct, as Ms. Hardy said. She reviewed the testimony, and there's nowhere in there about AFEs. But if AFEs are a proper venue for rebuttal, then maybe now, since he's here, maybe now you want to try to get the rebuttal exhibit in. That's all I said before.
Yes, that would be great. It's just
Okay.
I wanted to turn to the paragraph 41. And I'm not sure which paragraph 41 this rebuttal exhibit pertains
It looks
to.
like you have help.
Have some help. That's what I'm helping hands. Okay.
So I'm going to sustain the objection because the question is outside the scope of the direct, because that's what we have in evidence.
Okay.
Now, do you want to try to get the rebuttal exhibit in? We'll
Absolutely.
go right ahead.
I just have to find it.
Yes,
Okay.
yes, and since it's not marked, I'll need help too.
Okay. So I
Where is it in
believe,
the packet.
where is it in the packet?
Yes.
It is about 6, 7 pages from the back.
I see a lot of EOG resources documents here. So I guess it's after that. What does it look like? Can you put it on this? Is this it here?
Yes.
I thought I've seen this before. Didn't?
I think we were accidentally
Oh,
looking
no
at it
wonder.
before when we were looking for the response to paragraph 44.
It's toward the end of the rebuttal packet.
Thank you.
Yeah, it's about 7 pages from the end.
Not mine. So mine's a little different, it seems, because it's not 7. But I'll find it. Give me a minute.
Okay.
Okay. I have it here. So this is your C5, you said?
This is C5,
C5.
correct?
Okay. All right. Go ahead and lay a foundation for it.
Okay, so this is the rebuttal to Marathon's Exhibit A, which is their well proposal, I believe, paragraph 41, but let's take a look at it.
And I think Marathon's A is admitted into evidence, right, Ms. Hardy?
Correct.
Okay, good.
Yes, paragraph 41. Do you have that in front of you, Mr. Baker?
Yes, ma'am.
Could you read into the record Mr. Miller's paragraph 41?
Yes, ma'am. The estimated costs of Marathon's proposed wells are fair and reasonable and are comparable to the cost of other wells of similar depth and length drilled in Lee County.
And you have looked at the AFEs of Marathon, is that correct?
That is correct. Yes, ma'am.
And this rebuttal exhibit has been prepared in light of your review of Marathon's AFEs, is that correct?
That is correct. Yes, ma'am.
And as a facilities and operations engineer, you deal with AFEs on a regular basis, is
I
that
create
right?
AFEs on a regular basis. Yes, ma'am.
So
I
you
would
move for
move the admission of rebuttal exhibit C5.
Ms. Hardy.
I object.
Okay.
Well costs are always an issue in a competing pooling case. And Tumblr had Marathon's AFEs well before we filed hearing exhibits, just as we had theirs. And if they had concerns regarding AFEs, that is an issue for direct testimony that should have been addressed in direct. They knew well costs were an issue. It is not arising as a surprise in response to Mr. Miller's statement.
Ms. Sheen?
If I understand correctly, Marathon made at least 2 changes to its well proposals, and some of their AFEs were incomplete or incorrect, and there were changes made to their AFEs. And I believe Mr. Baker has looked at all of those AFEs and compared them to what was attached to Marathon's exhibits, which, by the way, did not include all of their well proposals. They only included their last well proposal.
So Ms. Hardy, in response, Ms. Shaheen is saying that he didn't have the complete picture to look at when he was reviewing until he got your exhibit packet.
That cannot be correct because Tumblr had the AFEs. In fact, Mr. Villarreal's testimony makes a big issue of them receiving multiple sets of AFEs. So they had them, they knew about them. If they had criticisms of them, they should have been raised in direct testimony.
May I?
In just a moment, let me just think through this for a moment. So Ms. Hardy is saying that while it's true there were iterations of the AFEs along the way, your witnesses had the AFEs along the way, and that it wasn't a surprise. So what's your response to that?
My response is I feel like it's disingenuous for us to have all of this information about the AFEs in the record and not allow testimony from a witness who can compare the two in his area of expertise. And because the information is already in the record and before the division, I think it makes sense to allow a witness to assist the division by interpreting that information.
When you say it's the AFEs are already in the record, are you saying that they're part of the exhibit packet that Marathon filed?
Yes,
They are.
as long with the AFEs that we file. So Mr. McClure can himself go and look at the
Right.
AFEs, and all I'm doing is asking Mr. Baker to give his opinion, having reviewed all of the AFEs, to compare the two sets of AFEs.
So, Ms. Sheen, if you
Mhm.
could counsel your client not to interrupt while we're having discussions, it would be helpful. Because
Absolutely.
it keeps taking your attention away from what we're doing. It's not the first time.
And
Hold on, Ms. Sheen. The objection is to the exhibit as a rebuttal exhibit. Now, what I'm trying to decide here is, can you ask your witness questions about the AFEs without relying on a rebuttal exhibit? Because as you said, they're in evidence and it's within his scope of expertise. So based on what I've heard so far, I agree with Ms. Hardy that this is not a surprise to where a rebuttal exhibit is properly admitted. However, I think if you ask a question and there's an objection as to comparing the AFEs from this expert witness, then we'll deal with that objection separately. So I'm sustaining the objection to this exhibit, but that doesn't mean you can't ask your witness questions about the AFEs.
okay, so I would just say that the exhibit is in direct rebuttal to paragraph 41.
Aha. And paragraph 41, you've already read it, so you don't need to read it again. Could you bring it up on the screen? Could someone bring it up?
I can. Ms. Sheen would like.
It's in your notebook, page 13 of 241 in the
Oh, okay, fine.
Marathon
All right, hold on.
notebook.
What is it again?
Page 13 of 241 in the Marathon notebook.
13 and 241?
No, 13 of 241.
Oh, 13 of
In
241.
in the first exhibit package, which is 25541.
I don't have that open here. I have your book here of 320 something. So I don't have
You don't have the Marathon.
I don't have the marathon one in front of me.
Okay.
Miss Hardy, I don't think you gave me one, did you?
I didn't, but I can.
Oh, you have one too?
think I
didn't
have
think
it.
You had one.
I think I have it right here.
Okay. And Miss Hardy, if you do have one, I would like it if it's for me to keep. If it's a loaner, I don't want it. 41? Thank you. Is this your own?
Oh, yeah.
You have more?
I have it on the screen now.
Wow.
Oops.
Okay, so here's paragraph 41. The estimated costs of Marathon's proposed wells are fair and reasonable and are comparable to the cost of other wells of similar depth and length drilled in Lee County. So you're saying that this is a rebuttal to this paragraph, which you only saw when this was filed. Ms. Hardy, why is this not a surprise?
Well, Mr. Villarreal deals with AFE cost at his direct,
Okay.
and he provides exhibits on them and testimony.
Okay.
So clearly they knew that the AFEs were an issue. And so I feel like this is coming back after the fact, after they realized they didn't have the right testimony and are trying to fix that.
I'll object to Ms. Hardy testifying on the record.
It's my objection. I'm not testifying.
Exactly. She's not testifying, Ms. Shaheen. We already went over this. Okay, so Ms. Shaheen, what you're saying is this fair and reasonable, that the costs are fair and reasonable is a surprise.
We're just saying that this was filed with their exhibits, including their AFEs, and we are now responding to their exhibits and their representation that their AFEs are fair and reasonable and comparable to the cost of other wells of similar depth and length. And in light of that testimony that was filed, Mr. Baker has looked at the AFEs closely and compared them. And I'm just asking, I'm happy just to ask him. If we don't want the exhibit, fine. I'll just ask him the question.
Yeah, I'm gonna now that I see the language of 41, I'm gonna stand by my ruling, which is, that's not it's not a proper rebuttal exhibit. So C5 does not come in. It's excluded. However, I've already given you an opportunity to ask your questions about the AFEs, and we'll see if we get an objection, what we're gonna do.
Okay. Mr. Baker, have you compared the AFE?
Yes, ma'am.
And what is your opinion of Marathon's AFEs?
My opinion is that I believe Marathon's AFEs are extremely vague and unspecific. And total gross CapEx is lower than what I would expect as far as drilling a 2.5 mile lateral at comparable TVDs in this area.
And did you compare these AFEs that were attached to the exhibits, Marathon's exhibits? Did you compare those AFEs to the AFEs that were submitted in October of 2024 when Marathon proposed the wells under the forced pooling orders?
I did, yes, ma'am.
And what is the difference between those two sets of Marathon's AFEs?
It's roughly a 30% reduction in CapEx.
So,
So the new AFEs being 30% lower, 29.8% lower than the previous.
and,
Just speak a little louder so the microphone picks you up.
Yes, sir.
I'm just cautioning you.
and so does that make sense to you that costs for drilling these proposed wells would be 30% less a year later?
Not in my
Object to the
opinion.
form and the
What's the
foundation.
objection?
Well, I think it's misleading
Why?
and argumentative.
Why?
It's also a leading question on direct.
There's been many of those and they haven't been objected to until, here and there. But why is the form a problem?
Well, it's asking him to comment on the reasons that Marathon's well cost changed when he doesn't have any information on that.
So why don't we provide a little more if this witness knows more about why he's advancing this opinion, which is sort of coming out of the blue, it would be helpful to understand why he thinks this. So I'm going to sustain that objection. So that answer unfortunately has to be stricken. And I know you're not going to really do it, Mr. Court Reporter, but I'm saying it anyway. So why don't you provide some foundation for that answer, if you have any?
Okay, so you testified previously that you create AFEs on a regular basis, correct?
Yes, ma'am.
So you're aware of the cost of drilling wells, is that right?
That's correct.
And you're aware of how costs change from year to year in terms of drilling wells, is that right?
That is correct.
And in terms of building facilities.
That is correct.
And so would you expect that AFEs, the costs for drilling wells, the same wells that were previously proposed a year ago, would you expect those costs to decrease by 30% a year later?
In my opinion, in my experience, I have not seen that unless there was some sort of black swan event in the market. Like COVID, for example, where you would see something like that.
And
But
has there been any kind of black swan event that you're aware of in the last year?
not to my knowledge, and I haven't observed those types of discounts in my experience at UConn and Tumblr.
And in your review of Marathon's testimony, did you find any justification for a 30% decrease in the AFEs for the drilling costs in this matter?
No, ma'am. The AFEs are extremely unspecific, and it's extremely difficult to find where that cost savings is being enjoyed.
I have no further questions.
So Ms. Shaheen, you asked the witness about comparing to, was it October of 24, I think, AFEs?
Yes.
What is the date of the new AFEs that you are using to compare with last year's?
June 2025, sir.
Thank you. And that's after the merger.
That's correct.
I'm going to call it a merger. Okay, all right, Miss Hardy. Is it not your?
Is it my turn? Oh, okay.
Have I lost my way? I thought it was time to cross
Maybe
examination.
I've lost my track.
Okay.
If you have no questions, we're fine with that.
I do
How
have
quick
questions.
you are.
Okay. Make sure I've got the right thing here. Mr. Baker,
Yes, ma'am.
Tumblr does not currently have any surface infrastructure in this area, correct?
Yes, ma'am.
Okay. And actually, I was going to pull up your testimony. Get there. Okay, and I've got here your testimony pulled up, which is Exhibit C. And here you are talking about, and I am looking at paragraph 1 of your affidavit, and you're comparing the surface facilities between Marathon and Tumblr's proposals, right?
Yes, ma'am.
Okay. And actually here, I think you're just providing Tumblr's,
I'm actually just describing the surface disturbance in this first.
right?
Yeah, that's right.
Okay. And so Tumblr's plan impacts 37.84 acres of total surface disturbance, right?
That is correct.
Okay. And Tumblr will have 4 well pads versus Marathon's 2, correct?
Yes, ma'am.
Okay. And so you don't dispute, and I don't think you do, that Marathon's development involves, I think you said earlier, 45% less surface impact than Tumblr's.
That's correct.
Okay. And your exhibits on water infrastructure, well, let me ask this first. You said several times when you were testifying, we have pipelines in the area. And by we, you weren't referring to Tumblr, were you?
No, ma'am.
Okay.
No,
You were saying that there are pipelines in the area.
that's correct.
Okay. And that's true for water.
Oil, gas.
Okay.
Yes,
All
ma'am.
of the takeaway
That's
that
correct.
you would need. Okay.
That's correct.
Okay. And Marathon does have operations in adjacent areas, correct?
Yes.
Okay. So it would make sense for them to use surface facilities that they have available that exist for adjacent areas, right?
It just depends. Yeah, it just depends if it's applicable.
Regarding the AFEs, that you were just questioned about, and I think the hearing examiner asked you a question about this fact. So you were talking about AFEs changing between October 2024 and then the more recent AFEs that I think are June or July of 2025.
June of 2025.
Okay. And those are Marathon's AFEs that were sent in October 2024.
That's correct.
And then Marathon's AFEs that were sent in June of 2025.
Yeah.
Correct? Okay. And we've talked about it today, and I know you've been here listening, and you're aware that ConocoPhillips acquired Marathon in November of 2024, right?
I don't have a comment for, yes, yeah. that's
Okay.
fine.
So
Yeah.
the October 2024 AFEs were sent prior to an acquisition by ConocoPhillips, correct?
That's correct. Yes, ma'am.
Okay. And generally speaking, economies of scale can result in reduced cost, right?
Absolutely.
And when an operator has existing infrastructure in an area, that can reduce costs, correct?
Yes, ma'am.
Okay. And here, Tumblr plans to use 4 well pads and Marathon will use 2, right?
Yes, ma'am.
And presumably, well, let me ask it this way. Is it fair to assume that lowers costs?
No,
Going from 4 well pads to 2 doesn't make,
not if, well, I should say a normalized cost or a total cost, two different things. So if you're looking at a total cost per well, and you just mentioned scales of operation. So if I'm scaling up my operation for a unit from 17 to 31, then my costs normalized will be lower typically.
just looking through my notes. So to be clear, you are raising issues with Marathon's AFEs because they are lower. They're lower than tumblers, correct? We all agree.
That's correct.
Okay. And do you have any knowledge of how well costs work under a pooling order?
Yes, ma'am.
Okay, so if cost ended up being higher for a pooled unit, working interest owners can object, right?
Yes, ma'am.
And they can argue that the costs are higher than they were in the AFEs, right?
Yes, ma'am.
Okay. Those are all of my questions. Thank you.
Mr. McClure,
No questions, Mr. Hearing Examiner.
redirect.
A little bit, please. Ms. Hardy asked you whether Marathon facilities already existing in the area would reduce well costs, did she not?
I believe so.
But those facilities, to the extent they existed when those October 2024 AFEs were issued, correct?
Objection, lack of foundation. I don't think he would know when facilities existed and who they were operated by.
If you know, do you know whether?
Hold on.
Okay.
Again,
Oh, sorry.
we have to
Waiting for
get
that.
this
Okay.
system down here with
Okay.
objections. I mean, the witnesses have learned not to answer when there's an objection, but so there's a lack of foundation for this question. So what information are you trying to elicit from the witness?
Well, I'm referring specifically to the information that Ms. Hardy already elicited
Okay.
from, he's already testified to this. So I'm not sure what foundation needs to be testified,
It would help
needs to
me
be laid.
if it would help me if you told me what question did Ms. Hardy ask that she got an answer to, which
Yeah.
is what?
Ms. Hardy asked whether facilities existing in the area for Marathon would result in less costs for the AFEs.
And you remember asking that question?
Yes, but they're two different companies.
Right, I understand.
Yeah.
that. I'm with you. I get that. I get that we have Tumblr and Marathon here. Okay, so she asked that question, and now what's your question?
Well, actually, I need to ask a clarification of Ms. Hardy, because what I understand her to be saying is that Marathon and Conoco are two different companies. Is that what
Well,
your
we have,
position is?
no, we can't do that.
Okay,
What we can do is we have a question, we have an answer from the witness. Now, if this is your witness, you're on redirect. If you're trying to clarify something that the witness may have misunderstood or whatever, you have the ability to do that now. But there's an objection to the question you just asked as lack of foundation. So either you tell me why there's a foundation here. I understand that you said Ms. Hardy asked you this before.
uh-huh.
That's not necessarily, I understand that it's a branch off that. So what is your new question? Ask me.
Ask you?
Yeah, I'm not answering it, but tell me what the question is. Because I forgot what it was. That should be obvious at this point.
Well, I'm trying to address
Yes.
the testimony that Ms. Hardy elicited with respect to less costs
Right.
resulting from Marathon having facilities in the area.
Okay. So I think you can get at that answer by laying some foundation. Ask a few other questions to build up to your ultimate question. So I sustain the objection, just rephrase.
Okay. Do you recall Ms. Hardy asking you about facilities owned by Marathon in the area?
Yes.
And do you recall Ms. Hardy asking you whether the existence of such facilities would result in decreased costs for the AFEs?
I recall her mentioning in the context of cost reduction in the.
Would it be helpful to have the court reporter repeat the question that she asked and the answer given? Or do you feel like you know what it is?
That would be helpful.
Okay, can you do that?
Yes, one moment, please. Do you recall Ms. Hardy asking you about facilities owned by Marathon in the area? Yes. And do you recall Ms. Hardy asking you whether the existence of such facilities would result in decreased costs for the AMEs?
Mr. Court Reporter, I meant, can you go back to when Ms. Hardy actually asked the question and we got an answer?
Yes, sir.
Thank you.
Okay, I believe this is it. Please let me know if I'm incorrect here. And generally speaking, economies of scale can result in reduced cost, right? Said absolutely. And Ms. Hardy went on, okay, and when an operator has existing infrastructure in an area that can reduce costs, correct? He responded, yes, ma'am. Okay, and here Tumblr plans to use 4. Well, pads and Marathon will use 2, right? Responded, yes, ma'am. Said, and Ms. Hardy went on, and presumably, well, let me ask it this way, is it fair to assume that lowers costs going from 4 well pads to 2? He responded, I should say a normalized cost or a total cost, 2 different things. So if you're looking at a total cost per well, and you just mentioned the scales of operation. So if I'm scaling up my operation for a unit from 17 to 31, then my cost normalized will be lower typically.
Ms. Sheen, does that cover the ground or is that not yet there? Are we not there yet?
I don't know. I mean, I have an understanding of what I believe Ms. Hardy was trying to elicit testimony about, and that's not quite there.
Do you remember the
but
question you asked?
Can I
think Ms. Shaheen is referring to those questions,
Okay.
but I don't think I don't think I elicited, I don't think what
Okay.
she
Do
thinks
you
I
need
did.
us to read more? Did you need the court reporter?
No, I don't
No.
think so. No. Can I go about it a different
course,
way? And
definitely.
if this doesn't work, we'll let it
Fine,
go and
right
I'll
ahead.
try to get there some other way.
Mhm.
You testified previously about the differences between the October 2024 AFEs and the June 2025 AFEs. Do you recall testifying about that?
Yes, I do.
Does the existence of facilities, to your knowledge, are there facilities that would impact that decrease or would result in that decrease that you observed between the October 2024 AFEs and the June 2025 AFEs?
Not to my knowledge.
Thank you.
Okay.
I'll move on
Okay.
from there. And when you reviewed the AFEs and tried to compare Tumblr's AFEs to Marathon's AFEs, were you able to actually make a comparison?
No, I wasn't.
And why is that?
Because as I mentioned before, Marathon's AFEs are extremely vague and unspecific. I can give examples if you like.
I think that is sufficient for me now. And I have no further questions.
Okay. Recross on those questions?
Just one or two.
Sure.
Mr. Baker, Tumblr never asked Marathon to provide additional detail regarding its AFEs, did it?
Not, it's out of my scope. I don't manage the communication between Tumblr and Marathon, so I can't answer that with a, intelligence.
So you don't know whether Tumblr requested any supplemental information regarding the AFEs that you say are vague, correct?
That's correct.
Okay, thank you. No further questions.
Mr. McClure, did any of that raise an issue for you?
No, it did not, Mr. Hearing Examiner.
May this witness be excused?
Yes, you may.
All right. Thank you, sir. Mr. Villalobos? Villarreal?
Mr. Examiner, could we take a 5-minute break
I think we need
very
one.
quickly?
All right, we're off the record for 5 minutes.
Thank you.
My bad. Didn't. First time. No one's ever called you Villalobos before. Oh, that part. No, yeah. That's all I'm talking about. Oh, yeah, my bad on. Oh, no worries. Sounds familiar. Do you have West Point or? Frame? Dylan. I know, I think I think you recognize that name. Or the Army side. That's what Chris said. Philip on water. Yeah, so there's another brain in our midst. Just a good friend of mine in Texas, who's a public defender, used to be a prosecutor. But I think he knows Dylan. You ever use umbrellas? Yes. That we put. Maybe. Let me look. That could be it. Yeah, hold on. Maybe not. You don't have a lot of public. I wouldn't think so. I would hope not. Yes, Kirkland and Ellis. That's exactly right. Happily. Happily? Yes, that's where he is.
Actually type on one of those like core reporter keyboards or?
No, no, sir. I do not. I don't know if I have.
So you're typing it like full verbatim?
So I'm not a court reporter per se, digital reporter. There's a difference between just how records taken. So I use audio to supplement, notes to supplement the audio, then transcripts created.
That's
Typing as much as I can.
respect.
Oh, fantastic. Thank you. Thank you. This one, I don't want to keep this. It's back to you.
Do I get one? Is that our only one? If not, I can just.
Well, I think it'll be easy enough to get to D15 because it's the last.
It's the last, so it's the EOP.
Is that right? That the rebuttal is in
It's already-
D15.
I can see the numbers on mine.
Michigan's rebuttal exhibit?
Yeah. They're So machine A7 was admitted. A8 was excluded. D5 was excluded. Now we're working on D5.
Well, I believe we're working on D and all of the, of the packet, yes, of the rebuttal exhibits.
That they rely on.
That's correct.
That's where we are. Okay, I'm ready to start. Your Villarreal, you're on the road.
Yes, sir.
And if you could sit close to the microphone and speak clearly, it would be helpful. Thank you.
And Mr. Examiner, I'm going to ask you to help clarify how I should proceed. And I'll state, because when I read Marathon's objections, the only portion of Exhibit D that they seek to exclude is paragraph 7. And I just want to make sure that I understand that correctly. And so that I can proceed, and then we can deal with paragraph 7. And then perhaps from there, we go to the sub-exhibit. If Ms. Hardy agrees with that, with my understanding.
Paragraph 7.
I just want to make sure you're not trying to exclude the entirety of Exhibit D. Because for some
No.
reason I got that impression earlier today, but that's not what the objection says.
It's paragraph 7, which is the bottom of page 4 to the middle of page 10.
Okay.
And I'm not sure if that's so I also have another objection, if you want me to raise it.
The D on its own,
Yes.
but what is the objection?
Well, now, because the prior witness has testified about AFEs pretty extensively, and Mr. Villarreal had addressed AFEs in his testimony, including at the bottom of his affidavit at page 3, I object to him discussing the AFEs on the ground that it's cumulative evidence. It's been addressed now by their prior witness, and they chose to proceed that way.
So the way I understand the rule is that it's up to the hearing examiner to exclude repetitive, I can read it well in here. I think it is. Hold on a second. Here it is. Okay, in 1915 417A NMAC, it says the commissioner and division examiner may admit relevant evidence unless it is immaterial, repetitious, or otherwise unreliable. So the word repetitious is the word you're focused on.
Correct.
You're not saying it's immaterial or unreliable.
Correct.
Okay, well, I'll make a decision on whether it's repetitious after I hear the testimony. So, Ms. Shaheen, why don't you start with this witness and the way we have been doing it, and then we'll deal with the exhibits one at a time.
Thank you. Mr. Villarreal, do you see on the screen here, I'm showing your self-affirmed statement, which is labeled as Exhibit D.
Yes.
Do you accept this statement as your true and correct testimony today?
Yes.
And do you have any corrections to this testimony?
No.
Turning to paragraph 5, which begins at the bottom of page 1 or 215 of 328. You opine that TOP's development plan, TOP being Tumblr, development plan is superior to Marathon's proposals for a number of reasons. Can you summarize those for the hearing examiners, please?
Yes, so that is looking at Exhibit D10, details why Top or Tumblr's David development plan is superior to Marathon's Goliath development plan. One, we believe that Marathon is wasting potential recovery in the Wolfcamp A due to their ultra-wide spacing with minimal marginal uplift, only about 10%. We believe they're ignoring co-development in the Third Bone Spring sand. We believe that they are underdeveloping the Second Bone Spring sand with their greater than 1,500 per foot spacing. And we believe that they're abandoning proven reserves in the Avalon and Third Bone Spring carbonate.
And then are there details? Let's turn to first Exhibit D10. Which compares Tumblr's and Marathon's development plans. And can you highlight the important points of Exhibit D10?
Yes, so you can see Tumblr's David unit, we're proposing 31 wells as we've gone through today. Marathon, Conoco, 17 wells. What you can see is, the estimated ultimate recovery of substantially more, 52.9 MMBOE compared to 29.6 MMBOE, Tumbler versus Conoco. Then going down, really rehashing the same stuff that I had just discussed.
And if we turn to Exhibit D11F, I understand this is Tumblr's type curve. Let me find that for us. This is D11A. Can you summarize your opinions here on D11A?
Yeah, so just broadly, D11 is just providing type curve support for all of the formations that Tumbler plans to develop with David. Here is the overview of our Avalon type curve. 15 offset wells, our expected EURs. I don't know how much detail you want me to get into here.
Well, let's just walk through each one to make sure.
Yeah, so we have the Avalon, we have the first Bone Spring sand, we have our second Bone Spring sand, we have our third Bone Spring carb, our third Bone Spring sand, we have our Wolfcamp A, and then we have our Wolfcamp B. So at Wolfcamp B, that's the 80% water cut. Also the same target that Conoco or Marathon intends to develop. And
Mr. Examiner, do you think it might be helpful, expedient for us to address? I'm not sure whether Marathon is objecting to Exhibit D11. I don't think they are, but I just want to double check. That's why I'm a little bit confused, because when you I'll just say
No, I think that we don't object to these.
We see these going.
To the D11 point A through, is it G?
Yeah, I think it's D11A through D11G. And so, because when I look at the objections, I understood that they were objecting to paragraph 7 of Exhibit D, to Exhibit D3, Exhibit D4, Exhibit D5, and Exhibit D9. And so if we can proceed with that understanding, then I think it'll be a lot easier for us. Because like Mr. Examiner, at the beginning, I thought I heard you say you objected to all of the Ds, but if that's not the case, that would make these more expedient.
I wasn't willing to stipulate at that point to the admission of all of them, but I don't necessarily object to all of the Ds. I don't object to these that you're asking about.
Okay, so maybe we walk through all of them
And maybe
briefly and
this way. So Ms. Hardy, may I have a list of the D exhibits that you are objecting to at this?
Yes.
I did write D1 through 15 as objecting.
Okay. So, well, we object to the certain paragraphs in his affidavit,
That's paragraph
Right.
7.
and then now also the information on the AFEs being cumulative.
Cumulative.
So I have some objections that have come up today that I hadn't raised, right? Because they're new today.
So in D, the parts that you object to are paragraph 7, and there's a bunch there, it's about 5 or 6 pages.
Right.
And the AFEs.
Within, yes.
Okay, now what about D1 through 15?
Okay. So we object to
Mr. Villarreal, while she's looking for her objections, which paragraph in your self-affirmed statement deal with the AFEs? And Ms. Hardy, you know your objection, just speak up.
Sure. Oh, yes. We object to exhibits D3,
3,
D4,
4,
D5, and D9.
D9. So then, Ms. D1, D2, D6, 7, 8, 10, 11, 12, 13, 14, and 15 are admitted evidence.
that sounds good.
Good. Why don't we work on the other exhibits? Let's, I guess you were discussing, what's it, D15 or D11 with your?
We just discussed D11, and I don't believe there's an objection to D11. If you like, I can address each of the ones that are objected to.
That'd be good.
Okay,
And let's leave D out for a moment. Let's just start with D3,
okay.
private foundation.
So are we off D12?
No, sorry. Oh,
We're off
paragraph.
D12.
Yeah, we're done with D12.
And you were gonna tell me what paragraph you dealt with the AFEs in your self-affirmed statement?
Yes, I believe I talked about the AFEs and it's exhibits D6 and 7. So that is the paragraph at the top of page 9. And yep.
That's what? What is that? What do you add?
Oh,
I asked
wait.
you for a paragraph number in your self-affirmed statement, exhibit D. Discussing. Ms. Hardy, you objecting to it?
I have it in front of me.
Yeah.
It And it's a little confusing the way the paragraphs are numbered. It is paragraph 5G at the bottom of page 3 and the top of page
Oh,
4.
Yeah, page 217 of 328.
Yes.
Okay, so G, I see. With paragraph G, within paragraph 5, so 5G, thanks. Now I know that. And are you still objecting to D15, which is the rebuttal exhibit? I didn't hear you say that in your list.
Yes.
Great, so I better write that. So D15 is not admitted in evidence. Sorry, is that correct?
Correct.
I want to make sure that I got it correct. Okay, so Ms. Shaheen, why don't you begin with D3, 4, and 5, and let's work through those. See if you can provide foundation.
Okay, 31.
And it's on the screen in front of us.
Right, right. And I'm just looking for the paragraph in which Mr.
I think it's kind of cut off, so if you could zoom out a little bit.
On page 8, 2222 of 328. Mr. Villarreal includes testimony about Exhibit D5. This relates to the communications. Oh, this is D3. Sorry. Relates to Marathon's projections on Exhibit 2. So this builds on Exhibit 2 and shows that. Well, let me ask you, Mr. Villarreal, what does Exhibit D3 pertain to?
Yeah, could you zoom out just a
yeah.
little bit on the exhibit? Okay. So part of this is we look at planning and think about development. We have to think about the risk that this project will actually be developed, you know. And then I think when we look about the risk, one way to look at it is what does history say? So we look at the track record. And one way to look at the track record is by looking at the wells that have actually been drilled by Conoco or COG that have come out of, that have had pooling orders. So here, what we can say, if we were to go on the NMOCD website and search for Conoco and COG pooling hearings and cases, and then for each one, we double click into it and look at what was the working interest for Conoco and COG in those cases. That is what we're binning here. And so you can see, you know, the line at 100% shows that there's roughly 25 cases there. You know, that's 60%, there's roughly 10 cases there. And these are representing the cases that resulted in wells actually drilled. You know, what stands out here is when you look at where the David Goliath working interest is for Conoco, which is far to the left with their 43%. You know, I think the risk of this slipping on the drill schedule and not actually being developed is further reaffirmed by their statements. If you go all the way back to when we first started engaging with Marathon, prior to the merger being as Conoco is representing it on their own website, Fraley Duval, 18 months out, to be September 2025. go into March 2025, won't be developed in 2025. Sean Miller, these wells are discretionary. There's a typo, it says Q1 of 2017, but Sean Miller, in March of 2025, that should say Q1 of 2027. It's a correction. What's further troubling though,
Mr.
when I look at
Examiner.
this,
I'm really sorry to interrupt, but I think the question was, what is this exhibit showing? Because I object to the exhibit. So he is testifying about what he wants to establish that I have objected to. I mean, I think this is a narrative that's going on and on about an exhibit that's under objection.
I understood that the hearing examiner asked
For foundation.
for foundation for Mr. Villarreal to explain what was the basis for this exhibit.
Let me stop here.
Uh-huh.
What you need to do at this point is show how this exhibit is relevant and reliable. That's the foundation I need to hear. I don't need to understand what it's saying because I can see what it's saying. And I agree with Ms. Hardy. So I'm stating the objection, but please ask questions to this witness of how he produced this, why it's relevant and reliable, and then we'll make a decision on whether it comes in or not.
And that's what I understood him to be explaining. He went to the OCD website.
Oh, I heard he said.
And so do you want more foundation other than he went to the OCD website and pulled down the force pooling orders? I mean, this is what he did, and this is what an expert of his type does when it's considering planning and development, and from an engineering perspective. So I feel like he's laid the foundation. He relied on OCD public records to conclude that the percentage of interest here that Conoco has or Marathon has.
You have to say.
Okay, so I guess I'm just a little bit confused because the foundation. Okay,
The objection.
okay,
Basically testifying as though this was admitted. It's not been admitted. So all I need is a foundation, and I got it in the first minute or so, but then he went on.
okay, well, I didn't want to interrupt him,
Okay,
but
she did. And
she did, that's right. And so then, then I guess the only other, right, the only other foundation that we need to lay is that the communications were, where do you find the communications that you relate here in your exhibit?
those would be, I think, Fraley Duval, Caroline Frederick. Those are emails, the theme of the day. Sean Miller's, that was a phone conversation, Sean Miller, Nick Weeks, September 3rd, 2025. Caroline Frederick, we've already seen that email today on March 19th, 2025.
So do you have personal knowledge of these emails and communications?
Yes.
Okay. Ms. Hardy, basically this data comes from the OCD website, so the reliability is whatever it is. And these quotes are firsthand personal knowledge of this witness. So what is the objection now of this exhibit?
Sure. So first of all, I think these are excerpts of the quotes. We've been through that at length today. I think they're taken out of context and incomplete. Regarding the data here, I have a lot of questions about it. Not about the data on OCD's website, but about the interpretation of it and how it's listed here. He's saying there's a zone of apathy that I absolutely object to.
Okay. Why don't you, so she's laid at the
Okay.
beginning of the foundation,
I can ask.
but the objection remains.
Yes.
So now she's gonna voir dire your witness.
Okay, I kind of wish I could do my legal argument about how this is really not necessary under Rule 11-703. An expert can rely on.
I know the rule well.
Okay, so I I believe Ms. Hardy has the opportunity to cross-examine Mr. Villarreal about it, and it goes to the weight and not the admissibility. So I'll just leave it at that.
So, an expert and based opinion said in Rule 1173, I'm quite aware of that as a prosecutor, who brought many witnesses who were experts to trial. I know it very well. But this is more than just his expert opinion here. Do you see the difference? This is a bunch of data here that he's presenting as an expert that we have to determine whether it's relevant and reliable. Now, Ms. Hardy has objected to it. And so she's going to voir dire your witness to find out the basis of this exhibit. It's not just his opinion, because you could have asked him his opinion and we would have gotten his opinion. And that's fine, but this is more than his opinion. So you were trying to get this in. So you understand at this point? You don't seem like you do.
No, I mean, I just feel like this is going well beyond the rules of an administrative proceeding. And this is not a criminal trial. It's not a civil trial. And the rules of evidence don't necessarily apply. I think it should all come in and the hearing examiner should give it the weight that it deserves. That's my opinion. But obviously that's not your opinion. So Ms. Hardy is free to voir dire the witness about Exhibit D4 and all the rest of them.
So the foundation that you were providing was to show me that this is both relevant and reliable. Okay. That's where you differ with Ms. Hardy. Those are the rules that do apply in an administrative hearing. They're not the general rules of evidence, because we've already agreed that those are not applicable in the way that they would be at a civil or criminal trial. But Ms. Hardy does have the basis to object to the foundation of this and to show me that it's not reliable or not relevant. And so that's what she's going to do now. So you've questioned your witness. Now she's questioned. It's not cross-examination, it's just voir dire. So go ahead, please just keep it to relevant and reliable.
Sure, thank you. Mr. Browdial, looking at this exhibit, you have here percentages across the bottom, right?
Yes,
And one of them is 100%.
yes.
Okay, so you're showing, I guess my question is, if you looked at pooling orders, why a pooling order wouldn't be necessary if the operator has 100% of the interest, correct?
Not certain.
And you don't show here, and I can't tell. You look at ConocoPhillips pooling orders dating back to 2022. You didn't specify the actual operator. Were you looking just at ConocoPhillips?
Just as below, it says ConocoPhillips inclusive of COG.
Okay. And you don't know, when you look at a pooling case, whether the operator acquired additional interest after the order was issued, do you?
No. Say that one more time.
You can't tell from a pooling case how much interest the operator picked up after the order was issued, can you?
That's correct.
Okay. So you can't say with any certainty whether the interest that existed at the times the order were issued were the same as those that were existing at the time the wells were drilled, can you?
No, that would just shift it further to the right if that was the case.
Well,
But
you don't know that, right? You're assuming that. And you don't provide any data here on the formations, correct?
there's no data on formations here.
Okay. And you didn't look at the area of New Mexico, correct? whether it was Lee County or Eddy County or somewhere else?
I do not specify counties.
And you didn't look at or specify the number of wells that were involved in each pooling order, did you?
I do not have that on this table, correct?
And I think we've already covered the fact that these quotations here are just our excerpts, right?
Yes, those are excerpts.
Okay, I maintain my objection. I don't think this exhibit is reliable. It's not an accurate representation of wells that would actually be drilled by ConocoPhillips under pooling orders.
So any objection stands so far. I need to hear why this is reliable. I also need to hear why it's relevant, but I think I understand why it's, okay, I'm more clear about why it's relevant, or at least why I believe it's relevant. So that's not really the issue. The issue is reliability. Now, there was a question asked of the witness about why does this graph contain 100% ownership when you would need a compulsory pooling order for that? The answer was less than 100% sure. So you might want to ask some more questions.
Yes.
If you think this is an important exhibit, I think
Yes.
it's ultimately what decide.
I think it would be helpful, Mr. Villarreal, if you could tell us the parameters of your search. For example, did you limit the request to a particular county in New Mexico, or was this throughout New Mexico that you pulled these forced pooling orders?
This was throughout New Mexico. So this is Google search NMOCD cases, then search Conoco or COP, search COG, search Burlington, there was nothing, and then running through just the list of cases.
And Ms. Hardy asked you about the fact that you didn't consider whether Conoco may have acquired additional interests after the forced pooling orders were issued. Do you recall that questioning?
I do.
Now, and you said that wasn't relevant, right? It would just push the graph farther to the right, meaning they would have acquired more interest than is even reflected here. Is that right?
Yes.
And would that also account for the fact that some of these were attributed to 100% interest because Conoco, after the forced pooling order was issued, acquired additional interest?
Object to speculation. I just object on speculation.
Well, he did testify.
Well, these would have been
Hold on. So this is what here. Okay, so the questions are even
Okay.
broad. It's almost like foundational questions being trying to get piece of evidence admitted. You're allowed a lot of latitude to try to show. So I'm going to let that go. So continue, Ms. Sheen.
Well, to clarify, when Ms. Hardy asked you about whether you looked to see whether additional interest had been acquired after the forced pooling order was issued, and you said you did not, but if you had, it wouldn't really matter to your conclusions because it just meant that Conoco actually had more interest than it originally had when the forced pooling order was issued.
Yeah, correct.
Okay, and could that hypothetical scenario, if Conoco acquired additional interest after forced pooling order was entered, that could result in 100% interest, couldn't it?
It would have been pulled off of the documents that were listed on the NMOC website.
Right, so, okay. So you're saying the forced pooling orders Well, let me back up. Where did you get the information about the interest that Conoco had?
The filings that were published on, like, in the packets.
Okay, and so are you saying that the filings, the exhibit packages that were filed in these force pooling cases indicated that Conoco had 100% interest?
Yeah, it also could have been inclusive of Conoco plus COG, like multiple parties or different entities. So
So it could have been other interest owners who voluntarily
yeah,
participated
we
with-
summed Conoco plus COG plus Burlington plus there's one other Conoco family entities and Marathon.
And this was prior to the acquisition of Marathon?
Yes.
And was it prior to the acquisition of COG?
I think COG was before 2022.
Okay. So conceivably, the 100% interest could have reflected a Marathon interest that was not actually part of, that was actually being force pooled.
That's correct.
Would that explain the 100% interest that's on your table here?
That could, yes.
And I would just note, we're happy to provide all of the emails that relate to these quotes.
So, Ms. Janine, it seems to me, I mean, it's a valid objection that this document is on shaky grounds when it comes to reliability. I'm trying to be nice about this. And it seems to me that this witness could testify to his conclusion here in this paragraph without relying on a exhibit. And he can testify to the communications he personally had with these different witnesses, or not witnesses, Duval, Frederick, Miller, of course Miller's here, et cetera. He can testify to those. I mean, they're all personal knowledge to him, if we even had that standard here. So it seems that there's certain stuff that's reliable he could testify to without getting into this, what I would think is a messy exhibit. So I don't admit exhibit D3 based on the objection and based on what here that I've heard from this witness. So with that in mind, why don't you elicit testimony that instead of.
Okay. My question for you is, could we address each of these exhibits as to whether they're admissible, and then I could go back
Yeah.
and do the questioning?
Yeah, sure.
And that one might be less disjointed. Okay.
You want to start with four here?
So is it 4? Yes, D4. Mr. Villarreal, can you explain to us the information that you reviewed that forms the basis of your opinion in Exhibit D4?
Yes. So information that we reviewed, looked at, or I guess information we reviewed and what we kind of did here. Is that
Well, let's start with the information that you reviewed.
information that we reviewed? We looked at creating kind of an average well with our understanding of average Conoco working interest and NRIs. We looked at public statements from Conoco leadership, whether that be in earnings calls, oil and gas journal, or routers. And then, well, I don't know if I want to, then try to draw conclusions on, is there an incongruence between what is stated publicly by leadership and then what is stated in a pooling order.
With respect to the first column there, MRO Goliath versus base case, incremental MBOPD. And can you state for the record what you mean by MBOPD increase?
1,000 barrel oil per day.
And then did you look at data that related to numbers of rigs?
Yeah, so what we did here is we created a rig line, or excuse me, ran 13 rigs, made some assumptions on timings and working interest. You can see that listed in the note below. We said, based on what we're assuming to be average Conoco working interest, NRI, and what we felt was a typical well, what would the production increase be from those 13 rigs over 12 months? Then we said if they were to move 2 rigs and drill their 17 Goliath wells, what would that do to their 12 months of production? And what would be the impact at the end of the year? And we saw, because that would be measuring the impact of going from an assumed, 80% working interest, 64% NRI, down to we have a 43% working interest, 32% NRI.
And when you
And
say
that-
NRI, can you
Net
explain
revenue
it?
interest.
Okay.
And so what we found, again, this are based on assumptions, and this is directional. We don't have the actual data, but we do see that there is a shortfall, what we estimate to be 630,000 barrels of oil short after 12 months from the baseline case with 13 rigs. So then you have to think, well, if they make the decision to go drill these Goliath wells, how do they find new production? And there's generally 2 different ways to get more production. You can pick up more rigs or you can execute an acquisition. And we looked at what statements their executives have made to indicate the likelihood of them doing either one of those. And then we say, if those are or are not likely, how do we feel about the likelihood of them developing this, and what is the risk that Marathon continues to not develop Goliath, as hasn't been developed over 7 years, multiple permits, expired permits, pooling order extension, expirations. And we drew our conclusion that it is not likely.
At the end of your what year?
That's the end of my voir dire.
Okay, so I heard the word assumptions a lot, Mr. Bierico.
Yes.
And as an expert, you're allowed to make all sorts of assumptions based on facts, come up with your expert opinion, as long as it's within the scope of your expertise, and we've qualified you in a pretty wide range. Ms. Harding, do you want to, why do you written this down?
Sure. Thank you. Mr. Bianiel, regarding the assumptions, and specifically, I think I'm talking about the chart here that you have on the left, right?
Yes.
And that's where you used your assumptions, right?
Yes.
Okay. And so you assumed, and they're in these very small letters at the bottom of your exhibit, right?
Yes.
Okay. So you assumed 13 rigs at 15 wells per rig per year, right?
Yes.
Okay. And you don't know whether that is the actual number of rigs ConocoPhillips is running in New Mexico, do you?
I do not know.
Okay. And you don't know that each rig would drill 15 wells per year, do you?
As assumption.
Okay. And regarding the average NRIs that you have here, I mean, is the gist of this that ConocoPhillips, or really frankly, any operator, makes more money from wells when they have a higher working interest?
The gist of this is if you have production targets that you have to hit and you go drill lower working interest wells and lower interest, then you are going to have to go find how to make up for the less barrels that you have coming out of those lower working interest wells at some point if you're going to hit your production targets without picking up rigs or acquiring more acreage.
And you don't have any information in here that I see on some sort of on production targets. Have you speculated regarding the production targets?
We have comments from the executives, in the middle column, kind of middle portion in the lower 48, we plan to reduce capital spending by over 15% year over year while still delivering low single-digit production growth. And then that's from the CEO, Mr. Lance. That was a Q4 earnings call on February 6, 2025. Now CFO O'Brien, this is in the Oil and Gas Journal on May 12, 2025. He says, we're finding ways to deliver the same level of production for less capital.
And none of those comments are specific to ConocoPhillips operations in New Mexico, are they?
Those are not specific to ConocoPhillips in New Mexico. That's correct.
And ConocoPhillips has operations in many countries and many states, correct?
I would assume so.
Sorry, I don't think we need any more questions. Miss Shaheen, I find this exhibit to be the same. It's just on shaky foundations and it's too shaky for me to admit. Again, your witness can opine as long as it's within the scope and you're free to ask him questions subject to cross-examination. But the exhibit itself, I find problematic. So I'm not admitting this exhibit D4. Let's go on to 5, please.
Mr. Villarreal, can you describe for us the information that you reviewed to reach your opinion that's stated here in Exhibit D5?
Yeah, so D5, again, we're trying to assess, what is the risk that these don't go developed. So one way we're doing this, we're highlighting, the themes of the engagement throughout, and then also highlighting, the initiatives that Tumblr has brought forward to Marathon over the past 18 months with no success. We can start on the right-hand side, starting 2024, it's probably April, proposing an allocation of interest to Marathon at no cost in exchange for delivering or drilling Goliath wells, offering to sell them overrides at our cost to bolster their NRIs to incentivize development, offering to secure a drilling rig under the Tumblr banner with COP overseeing the operations. Both of those addressing low working interest, not having to pick up a rig. Guys, let us help you, please. Proposing outright purchase of Marathon's interests, initiating trade discussions for Top to trade out of the unit. And again, trying all of those to bring forward development and eventually with no other choice left, having to propose 31 2.5-mile wells. And each time on the left, you can see, what we've been met with, refusal to engage, as you would see in the emails, guys, I'm gonna be in Midland. I'll go to Midland. Let's meet. Let's go ahead and cancel tomorrow's call. No updates, no need to meet. Withholding the economic value. The Goliath unit won't be developed in 2025 and the drill schedule past 2025, still TBD. The breakfast meeting, that was, let's do dinner. I can't do dinner. No response. Let's do breakfast the day before. How about 7 a.m.? Okay. Book a plane, get out to Midland at 7 a.m. Only here, we can only commit to not working to let the permits expire. The deprioritizing of the assets and the deal dismissals. My team and I do not have time to go through our various portfolios to put a trade schedule together. After saying specific tracks, saying we want non-op, let's be done. Let's trade out of our interests. We want non-op. We don't have time.
Is it fair to say that this Exhibit D5 really is just a summary of the communications that you've had over the course of the past several months?
Yes,
Your
this is
personal
us begging and
communications.
pleading. Let's do a deal. Please, let's do a deal, guys. And every time getting shut down.
Okay, so this exhibit is based on personal knowledge.
And written communications.
Right, I understand. And you created this document yourself?
It's me,
Okay,
yes.
all right. Ms. Hardy, your objection to this document?
These excerpts are inaccurate and misleading. This is one of the ones I showed this morning where he's altered the quotation. Like for the one from Sean Miller, which Mr. Biardal has titled Deprioritizing Assets. And he highlighted in red there, COP is not developing the project. And the actual email, which I've used in Cross, I believe, or I will use it in Cross, states in 2025. So again, these are out of context. They've been altered. It's not a reliable exhibit.
So I see this, the deprioritizing assets quotation was not complete,
Correct.
as you just said. Are there any others here that are not complete, or can you be specific about how it mischaracterizes what was actually said?
They are snippets of more complete conversations, taken out of context. That's what I would say. That's the most egregious, I would say, false statement in this exhibit.
Mhm.
But the others are certainly taken out of context and they are incomplete.
I wonder, Ms. Shaheen, I don't have a serious problem besides what Ms. Hardy said, that one of these quotes just leaves out the in 2025, which is misleading. I haven't heard that the other ones are as misleading. They come from personal interactions. He can be cross-examined by Ms. Hardy based on the actual emails. She can ask to admit those emails that contain these quotations. But I wonder whether this shouldn't be revised to remove the quotations. In other words, using these words as sort of Mr. Villarreal's characterizations of the emails, so that the substance is there, but it's not factually incorrect or misleading. So this, I think you need to revise if you want to try to get this one in. I'm going to put it here as with a question mark for now. I'm not admitting it the way it is, because I agree that there is a factual misstatement here. But I think it'd be better if you did what I'm recommending, and then I would be much more likely to admit it, knowing that they're just characterizations, and then we can get Ms. Hardy to cross-examine him and bring out more, and possibly seek to admit emails. So leaving question marks there. D9, please.
Mr. Villarreal, can you please talk about the source of the quotes here and the notes in your second column? I do see that you've got some references here. If you could talk a little bit about those references. And then I understand that the third column is your conclusions in light of your review of the quotations in column 1 and the articles that are referenced in column 2. Is that right?
Can you say that ask one more time?
Yes. So do I understand correctly that the third column represents your opinions based on your review of the quotations and the reports or documents that that the quotations you identify in column 1 and the reports or documents that you identify in column 2?
Yes, correct. That's my opinion. That is based off of, column 1, column 2, then also my experience working at Bain & Company, which is kind of in the peer group with Boston Consulting Group and McKinsey for another large oil company working on very similar projects.
Ms. Hardy?
Mr. Examiner, this is so attenuated as to be irrelevant. It's not reliable. These are studies on potential outcomes of corporate reorganizations listed in this middle column, one from 2002. And then for Mr. Villarreal to conclude that will cause layoff-induced chaos. I mean, this is not relevant or reliable. There's no evidence that this applies to ConocoPhillips operations in New Mexico. These quotes on the left do not apply specifically to ConocoPhillips operations in New Mexico. ConocoPhillips operates in 15 countries. This is also beyond the scope of his expertise. He's qualified to testify as a reservoir engineer. He's not here testifying as a management consultant.
So, Ms. Shaheen, the title, or at least the biggest letters on the page, talk about headcount reduction may challenge future ops. They may, they may not. I don't have anything here that leans in one direction or the other. And you understand that the standard of evidence at a administrative hearing is a preponderance of evidence. That's how I have to judge these exhibits as well. I don't find the preponderance of evidence to say that this is reliable, that this is applicable to this case. So therefore, I'm going to exclude this exhibit as well, X. And we now have to go to, I think we should go back to D now. I think we really should focus on D.
And
Because that really
paragraph
is the
7.
crux. Sorry.
And paragraph 7.
I think we really need to talk about D here before we run out. Oh, it's almost 5 o'clock now. Yeah, let's, if the parties are willing, let's try to deal with D before we break for the night. Are you okay with that?
Yes.
Yeah, and because that'll give you time overnight to revise things while they're here with you,
Yes.
in front of you, hopefully, and then we can go from there. So let's deal with D. Would you like to focus on paragraph 7 and paragraph 5G?
Yes.
Go right ahead.
I'll start with paragraph 5G. Mr. Baker did not talk specific dollars about completed lateral foot consistent with industry AFEs. He just compared the two AFEs at issue, marathons and tumblers, and concluded that there was not sufficient information in marathons AFEs to actually determine what the differences were. Here, Mr. Villarreal is being more specific and actually talking about cost per foot So I don't believe it's duplicative or repetitive.
Okay. Ms. Hardy?
I think it is repetitive. The gist of this testimony here, it states right here at a certain price, the AFEs are unreliable given the prior estimates by Marathon. That is exactly what Mr. Baker testified to. And I objected to Mr. Baker on the ground that Mr. Villarreal addressed the same subject, or that he was the one disclosed in his direct as addressing the AFEs.
Okay, there's more to paragraph 5G though, so can we, an exhibit D7 is admitted into evidence. At this point, I don't remember what Mr. Baker